may be seated if you want to sit. You can stand if you'd like, but we're going to wait a couple minutes for the jury to come in because waiting for the defendant to come in and for the rest of the state team here. Thank you. Good morning.
Oh. Mm. Mhm. Mm. Mm.
Act Your Age, a Bounce original series. Go to bouncetv.com to see where to watch.
gonna,
Yeah,
Take
they're gonna
some.
nail me.
I think they are. All right, but it is nonetheless a sixth offense. Then you didn't show up for your screening. Matt modified things a little bit after you did show up. He got another day credit for fail to appear. So,
Depending on how you want to count that, I believe it was in the ROA as contempt of court. I don't know
Yes.
if you count that towards your credit
I
on the
would.
sentence. Okay.
I don't have to. I guess you're right. I don't really want you on probation. You got a charge pending in Indiana. I'm gonna give you 45 days credit too, leaving 43 days to serve. There will be some good time calculated in that. You will get out and then you can deal with your Indiana case.
Okay, my court date there is August 30th.
You'll be done with this by August 30th.
Okay.
There's a $300 fine, $75 crime victims' rights fee, a $50 state minimum fee. I'll cut the screening fee in half. The attorney fee is $150. Was there a police reimbursement for the blood draw?
It was not submitted in the police report that I obtained from the prosecutor's office.
All right, we'll just leave it out. 300 plus 75 plus 50 plus 50 plus 150 is 625. I don't believe I have any bond money. All right, you're gonna have to deal with your Indiana stuff, but you were a danger to the people here. Saying that you had a rough Christmas, then don't drive a car.
I know, that was
All right,
definitely enough.
all right, you go with the officers. Let me give you this envelope. I'll give it to your friend here. I'm gonna make that 625.
No,
By September 30th.
Keep my phone anyway there.
Thank you, sir.
That lady. Paul, did you have any other one today or just that one?
I think I've got one at 11.
If you've got anything early, we can start early.
You know which insurance you have, so I can send them up early.
Which one do you, which other one?
George Wood.
Oh, yeah, if you're here and he's here, we can start early. All right.
That's not driving it.
Oh. Sometimes it just is what it is. Mr. Schroeder's got some serious history and he's gonna have to deal with his circumstance in Indiana. They may well send him to prison, which isn't really a solution to drunk driving, but it does keep the public safe for a period of time. I went on a paperclip mining expedition. All right, we had, I think, 7 matters set. We've done three of them. Who do you have in custody? But he's not mine, correct?
It is not yours, sir.
All right, I'm gonna stop the record. Because you're gonna tell me when I start if I didn't turn it back on.
That or right, because I'm gonna be heading upstairs.
Okay. Usually they don't do things at 11:30 because that's when they eat.
Next, my in custody's coming at 11, well, this is at 11:30. And my 11 o'clock just showed up. Did you have a good weekend then, sir?
I had a very nice weekend, but it's time to get back to work. All right, I'm gonna step out for a minute. And if Paul comes in early, we got some real tough ones you have to do here. I'll be back in minutes.
One, and the judge is stepping out for a second. We'll be coming back in and see. Judge just stepped out. So,
Oh, okay. Yeah. No, okay. All right, stay with them.
but that's not an excuse. That's more mitigation. You understand? All right. I don't believe you'll be a good candidate for probation. So in each case, I'm going to find you guilty. Would anyone like to speak with regards to the cap? State you're asking for the 10 years?
Yes, Judge, I feel like the 10 years is an appropriate sentence based on the severity of this crime. This was a robbery with a knife, Judge. It's pretty scary. I think as the judges pointed out, as you pointed out, Judge, it's escalating behavior. So it starts as misdemeanors and then it goes up to these more and more dangerous activities, Judge.
All
I
right.
suggest to the court 6 years, Your Honor. He's no evidence that he's misbehaved in jail, that he hurt any police officers when he was arrested. He was cooperative with this court and with probation.
All right. Does anyone want to speak with regards to restitution?
Whatever the court orders, Your Honor.
Judge, that there's restitution to Jathan Cantu on page 5. It's JATHYN CANTU of $120.
Defense, do you have any objection to that?
No objection.
On page 6, it's restitution to Alan Hernandez of $1,078.
Any objection?
No objection.
There's no restitution on page 7. There's no restitution amount for the other victim. The third victim is Ali Sefraoui, ALI, and then the last name is SEFRAOUI. So I've just asked that the court order restitution to be determined, Judge.
All right. With regards to the restitution to be determined, the court is not going to allow that. This case has been on the docket since May, awaiting for restitution. And I find that when you say restitution to be determined, what ends up happening is somebody could say they want $30,000. And then Mr. Vitale, though he's done wrong, he won't have an attorney to address the issue of the $30,000. And somebody will just put that, and it'll take a while to clear that up.
Yes, ma'am.
All right.
Well, there's one final complaining witness, Judge. Sorry, on page 8, Damian Ortiz, he said that his monetary loss was $250, Judge.
Any objection?
No, Your Honor.
Mr. Vitale, your attorney is telling me that you have mental health issues and that you have drug issues. If you would like, the court could recommend the therapeutic community for you. It doesn't increase the time that you spend at the prison, but they can help you if you so choose. So would you like to be considered for the therapeutic community? All right, you'll still have to ask for it though. All right, and cause number 2023 CR 3033, the court will find you guilty, sentence you to 10 years in the prison. There's an affirmative finding of deadly weapon. This will run concurrent with 2023 CR 3036. Take in consideration 2023 CR 3034, 2023 CR 3035. There's to be restitution of $120 to Jathan Cantu, restitution of $1,078.
We have, we'll start, Mr. Alanis, you have your next witness, sir.
Angelica Hernandez, Your Honor.
Angelica Hernandez. Good morning, Ms. Hernandez. You have already been sworn in, is that correct?
Yes, I have.
If you continue under that same oath today, please have a seat on this side. You know what, Mr. Hernandez, actually, you know what? Yeah, I did believe that. I swore you in again with
Yes.
along with the 4 or 5 other folks that were with you. That's right. Have a seat.
Good morning.
Good morning.
You can just move the mic up. Could you please state your name for the record?
Angelica Hernandez.
And what is your relationship to Grizelda Hernandez?
She's my sister.
And what is your relationship to Dominic Hernandez?
He's my nephew.
Without giving me the address here in Laredo, did you all grow up together?
Yes, we did.
Okay, what's the age difference between you and your sister?
She's 9 years younger than me.
Okay. Your home, your childhood home, is it located on the west side of Laredo?
Yes, we grew up off of Mines Road, off of the first subdivision that was built in Mines Road.
And is that near Father McDowell Park?
Yes, it's about half a mile from there or less of that.
Did you all visit Father McDowell Park as children?
Yes, we did. We grew up at that park. All of us did, all my brothers and sisters.
Going back to growing up, what type of relationship did you have with your sister?
A good relationship. I was a big sister, so I want to think I was in some sort of way mentor to her. I would help my mom a lot with being the oldest. I would help my mom a lot with my brothers and sisters, especially my sister.
What kind of things would you all do for fun growing up?
Growing up, I remember I wasn't much of a doll player, but I do remember riding our bikes together, braiding her hair, taking care of her whenever we'd go out on family outings or just outside the house playing or at the park.
What type of personality, did Grizelda have growing up?
I feel she was, she was my sister. She was always happy. She was the more hyper one, I think, of my brothers and sisters. She was always my dad's favorite.
How many siblings do you have?
I have 2 brothers. They're both younger than me, and only 1 sister.
She was your only sister.
Yes.
Let's talk about the pregnancy that your sister had. When did you find out she was pregnant with Dominic?
I don't recall the month in particular. I do know it was after I had made my pregnancy announcement. We were pregnant together.
And did she ever tell you who the father was?
She did not mention his name. She showed me a picture of him.
Did you come to find out his first name?
After the baby was born, I found out his name.
And what name was that?
Anthony.
Was it just one name or his last name?
In the beginning, I only knew him as Anthony. As time went by, I knew his last name.
Okay. Did you know if he was being helpful or supportive of her pregnancy?
No, when my sister told me about her pregnancy and me and her spoke more privately, She did mention that she was going through with the pregnancy on her own, that the baby's father did not want to have anything to do with it. What she expressed was that he didn't want to move forward with the pregnancy, so she was doing it on her own. And that is how she presented it when she announced it to my family at the dinner table.
When you say he didn't want to move forward with the pregnancy, what did that mean?
She told me he had suggested that they terminate the pregnancy.
That she have an abortion,
That's correct.
and she decided against it.
We were raised Catholic by religion, and none of us believe in abortions.
Tell me about the day that Dominic was born. You remember that day?
Yes, I was with my sister in the operating room. She had a C-section. I remember hearing him cry when he was born. I remember feeding him his first bottle after the nursery released him to the room for my sister. She didn't wake up right after. My sister was allergic to morphine, so they had to use other medications to put her to sleep for pain control during her delivery. So she was very drowsy afterwards. I was waiting in the room when she came to the room and when they brought the baby. So I held him in my arms and gave him his first bottle.
Was he a big baby?
Yes, he was. He had chubby little cheeks, rosy cheeks.
And how was Dominic as a baby?
I think he was beautiful. He had the hugest lips I've ever seen. He had very, very full lips. He was a very, very good baby. Soon after 10 days, I had my baby. And I say good baby because I tend to get all the criers in the family.
And he was not a crybaby.
No, he wasn't. He was always very, very calm, he was a good baby, an amazing baby.
What role did you play in Dominic's life?
Well, as an aunt, I want to say I was very, very, very supportive of my sister. I think we all tried to be in our family. I would care for Dominic as he was getting older. Whenever my sister was going to school, she had classes, she needed to be elsewhere, I would watch over my nephews, both of them. And the same with me, whenever I had to go to work, she would try to take care of my children when I wasn't available for him. So you could say that we, in a way, raised each other's children.
How old would your sister be today if she were still alive?
I feel I could calculate how old she would be, but to me, she's always 27.
Why do you say that?
I can't see her aging over 27. That's where time stopped. That's where time is frozen for her. And like I said, I could calculate if I were to give you an age, she'd be, but she's 27 in my heart. And
what about Dominic? How old would he be today?
he would be 6. He would be turning 7, just like my son, July 26.
And what grade is your son in now?
He's going to 2nd grade.
Were they close? Your son and Dominic?
Yes, they were very close. They were very close. You could find him in my house fighting for Dominic's favorite basketball, or pushing each other, running down the hallway, fighting for sippy cups.
Dominic was an active baby.
Yes, he was.
What do you miss the most about your sister?
Her laugh. I miss her laugh. I miss her telling me that everything's gonna be okay. I miss her coming over to my house. I miss her cooking with me in the kitchen. I miss what most of us get to share with their siblings. We'd plan our children's birthday parties. We'd plan our outings together. I miss her very much.
What were her dreams? Her ambitions?
She was looking to eventually leave Laredo. She wanted to move to San Antonio after getting her nursing degree. She, as many of us, all of us have our struggles, and she wasn't one to just roll over and let time pass by or have somebody, come and pick her up. She always did her best to resolve any problems that were set in front of her. She was very self-driven. So I feel, her dreams, she would have met every single one of her dreams if she would have been given the opportunity.
What did she want to become?
She wanted to be a nurse.
Like you?
Yes.
Dominic was about 18 months old, right, when he died?
That's correct.
Do you remember what kind of toys he liked to play with? Was he a little boy?
Yes, he had, at my mom's house, he had these favorite little tiny yellow balls that he used to like hiding them from my mom, and having her find him whenever she was sweeping or cleaning, and she'd find him in all odd places, cabinets, under the sofas, anywhere. In my house, he enjoyed playing with the orange basketball that him and Tristan would always fight over. And any little games that they had that they could, tactile toys that they could press and they would make sounds. They loved playing with things like that.
So you like playing with balls, footballs,
Yes.
baseballs?
Yes, and they'd fight over this little tyke toy that you could get on top of and ride.
So he liked cars?
Yes, he did.
What about little tractor toys?
He did also play with little push carts, but more than anything, it was things he could ride on or balls he can chase after. They were both very active.
Did you like trains?
Yes, he liked trains. I think he had a favorite train at my mom's house also.
Would you take a lot of pictures with him?
Yes, I would. With both of them, him and Tristan, because my little boy would always get jealous whenever I would carry Dominic.
Can I approach you with this? Yes. I'll show you this.
Yes.
It's tender than the council. To offer 537, 538.
I'm sorry.
I'll move to offer 537.
Judge. Sorry, those numbers were used last week and they were sustained.
These?
Yeah. 536 through 540 got sustained.
We, sorry, did we use those numbers up? Or
Yeah, those numbers were already used.
All those numbers were used. Okay, well, I can see numbers. That's probably the problem. But so I'll continue with.
So, I guess if you haven't used 548.
550, that's the problem. That's two of them?
Yes, sir.
550 and 550. They're admitted without charge.
Motion to publish.
Yes, sir.
So I have this picture up here. You remember this occasion?
Yes.
Can you tell us what's going on?
Yes, we were at my sister-in-law's announcement. I believe it was at Rudy's. She was announcing her pregnancy, and that's me and baby Dominic.
I'll show you 551. Who's in this picture?
That's myself and Dominic and Tristan.
Also, would you video different milestones in Dominic's life, different events?
Yes.
When he was walking around and healthy?
Yes.
And what about how many birthdays did Dominic celebrate?
1.
And were you able to video some of his celebration?
Yes.
And what about verbal? Was he verbal? What are some of the words he was able to say at 18 months?
He would say hi, hi mama. He would call my mom mama, and hello, goodbye, go, stop, stay here. He would tell my sister whenever she wanted to leave, stay here. When she was leaving the room or leaving him to come to the kitchen with me. No, he whenever you would tell him not to do something, he would just scream at you, no, mama, or no, stop, or no, you, things like that. I feel he spoke a lot sooner than my son, even though they're just 10 days apart. He was more verbal than Tristan.
If I may approach you. I'm going to show you what Mark has. It's exhibit 548, 549, and 539. Is that? Sorry about that. I was saying 548 and 549. And then what would be this one? I'm gonna show you now these USBs. That's when you've seen these. You familiar
Yes.
with exhibits 552, 549, 548?
Yes, that's correct.
And do they accurately depict the video that you've seen?
Yes, that's correct.
And these are events that you would have videoed?
That's correct.
Quick break, I'm sorry. It'll be hopefully not more than 5, 6, 7 minutes, and then we'll bring right back in. Thank you.
And we have a break. They say 5 to 7 minutes, so double that, I bet. Oh dear. Let's see what's going on. Let me see.
That made me wonder.
Well, according to this, she was in front of Judge Pattison at a 267, and she was taken into custody. And this is another one. I don't know. Judge Pattison had been dealing with it, and then I ended up with it. I think maybe it's because Judge Pattison was gone and I inherited a bunch of his attorney pretrials in June. I think that's what happened. And so these cases got shifted to my side. But there is no bond. So thank you. Go ahead, Rhonda, or bond conditions.
Okay, very well. Well, just to correct the report, she has been living in Howe, Indiana with her boyfriend, not in Sturgis. She does seek mental health treatment, as she does have a lot of issues on board. I know that the last time she had done a jail sentence, it really, it was very upsetting for her. I don't know if she's ever spent any lengthy period in jail. You have? Yeah. Okay. It's been a while. Okay. I know that, she doesn't want to go back to jail. Can she do a term of probation? I don't know. I mean, I think she would like to try to get through a term of probation instead of doing jail.
In-person meetings too when I'm doing it.
Oh, okay. She indicates she's doing in-person AA meetings. Where are those at?
First Methodist Church in Sturgis. It's at 6 p.m. Thursdays and Fridays and noon on Tuesdays and Wednesdays.
Okay. Well, she's actively trying to maintain involvement in AA, so I think that speaks well on her behalf. But I definitely, you know, I don't know if she's as concerned as the court is, but I know that she definitely does not want to be in this situation ever again. But I think that alcohol is one of those things that you don't really know how bad it is until it gets bad and it gets the best of you. And I think that's what's happened to Miss Sullivan, that it has already gotten the best of her at her young age.
Miss Sullivan, are you working someplace?
Yeah, I work at McDonald's in Sturgis.
Okay. This case does have a strange posture. Because you didn't get, just like Mr. Aniqua, you didn't get taken to jail. And so you actually came to the court on March 23rd and you asked to confirm your court date. And your first court date was February 23rd, excuse me, March 23rd. So between your arrest for this and your court date, you got the disorderly person charge.
She's got a disorderly person charge pending, Your Honor?
No.
It's already been taken care of.
That was on March 7th. And so you came in here on February 23rd. They gave you a court date of March 23rd. And you were not on bond. You came in on March 15th and pled guilty to that. And I gave you a fine. Now, you came in front of Judge Pattison on May 12th, and that's when you were intoxicated, and then I saw you. So it's your first offense. You did not violate any bond conditions because you didn't have any bond conditions. In fact, you hadn't even been arraigned yet when you got the disorderly, and you were quite intoxicated then. So living in a hotel is very expensive. So what else would you like me to know?
I saw that I was charged in May, I think May 10th of 2022 for disorderly conduct, but that's physically impossible as I was living in Illinois at the time, and I wasn't even in the state in May.
That, I don't think that's right.
Yeah, no, that's wrong. And so
Well, no, you got the thing from Judge Pattison on May 12th, but your disorderly was in March.
I think she's talking about the May 10th, 2022 disturbing the peace that's on the.
Okay, well, let's look.
It was a 21 case, disturbing the peace, 7/8 of 21.
Darn it.
Looks like they actually just closed entirely because the restitution had been paid in May of 22. It's file 21-291.
Malicious destruction of building and disturbing the peace. 37 days, credit 37 days. You were in custody. And in July of 21, pled no contest to disturbing the peace, and I gave you 37 days credit, 37 days. So I actually spoke to you.
She recalls that now.
All right, and the 4 was a home invasion. It was bound over to the circuit court at about the same time. So those are accurate. Then the disorderly person was March 7th. So it appears the report is accurate. She was here in the jail and we had a polycom conversation and she resolved things. All right, so she's working. She's doing some treatment. It's a first offense. She didn't violate any bond conditions. So does that alter your recommendation, Autumn? You're just recommending flat 93 days jail?
No, the bottom of my recommendation is 24 months probation.
All right. Oh, 83 days deferred. I got you. All right. I had an oil judgment. I agree. We certainly need a probation. And I understand now, Autumn. Did Paul leave?
Yes, sir. I had to call into his office could call him, see if he can come back.
That's a lot of rigmarole because his client could show up on time. All right, we'll do the best we can. I sort of inherited a couple of these cases, but I don't mind. I used to do all the last pre-trials, so I got all the cases at some point, but I'm going to do 24-month probation, which means you can be on probation for as short as a year. I'm going to follow Autumn's recommendation, 93 days jail credit, 10, giving 83 days to serve. But of the 93 days, 83 are deferred. You're not going to do any more jail time if you do what I ask you to do. I got a bunch of jail hung over your head, but if you cooperate and do what we're trying to accomplish here, you won't do any additional jail. There's a $300 fine, a $75 crime victims' rights fee, $50 state minimum fee, screening fee of $100, attorney fee of $150, and $960 probation oversight fee. That can be reduced by up to $480 if you do this in a year. And the victim impact panel is $32. And was there a police reimbursement here?
No, yeah.
They keep neglecting to do it. That's $1,667. That's a lot for a young girl working at McDonald's. Doing 1 year. We're going to do alcohol testing as directed, which is probably going to be 2 times per week. Also drugs. You're old enough to smoke marijuana. If we do a test today, will marijuana be in your system?
Yes.
It's legal and you didn't have any bond conditions. As of now, you won't be able to use marijuana. Will anything else be in there?
No.
All right. We'll find out. Substance abuse counseling and treatment is directed, including 12-step meetings, and you're going to do the victim impact panel. You need a probation. I think everybody in here agrees with that. And I'm glad that my initial chagrin of you being intoxicated was misplaced and that you're 0-0 today. And you're doing some AA. Which one did you say you were doing? Presbyterian Church?
First Methodist Church in Sturgis.
All right. Autumn, is that your last one?
Yeah, sure.
All right, I want you to go downstairs. You plugged in. The difficult thing is going to be your testing, because you're not going to have a driver's license and you're living in Howe. But maybe there's something down there that we could utilize, but
I've already arranged for ride to and from work for in advance.
very good. All right, good luck to you, ma'am.
Thank you.
Karen Bennett. Thank you, Rhonda.
Thank you, sir.
This is file 231086 FY. And there's also a probation violation issue in file 222086. Karen Sue Bennett. Mr. John Bush is here with Mr. Bennett. Again, we don't have a prosecutor this morning. They're very short-handed. And Mr. Dan Friesine is here and he's prepared the report. Dan and I have had a number of discussions about this defendant over the months that she's been on probation. It's been a very difficult case for Daniel to supervise. She was on this probation and then she got this charge of attempting to resist, obstruct a police officer and operating while intoxicated, second offense. John, what would you like me to know?
It's interesting that looking at the report, other than open and tax in 2005, at least on its face, alcohol doesn't seem to raise its ugly face, so to speak, until the January 11th, 2023 OWI. And now we have piggyback a second one very soon thereafter. She's certainly not traditional age. She's 62 years of age. She's on disability, probably not going to become employed because of a shoulder injury, but is making a reasonable $1,306 per month on her Social Security disability. From what I can tell, and I met her originally at the jail, she was involved in services, doing AA, working with a therapist, doing peer counselor, and for whatever reason, she drastically fell off the wagon. I mean, troubling facts and circumstances in this new case. Since she's posted bond, she tells me that if the court would grant her the opportunity, she can go to a 14-day residential program in Kalamazoo tomorrow. And then she has plans to go to a sober living facility in St. Joseph County. And if that's consistent with what the court would order.
Which one is that? Hope House?
Yes.
I've shared with her that if that happened, she would be on probation and there would be serious consequences if she walked away from that program or didn't complete it. She tells me that she wants to change her life. She realizes that this is going very bad quickly. She also tells me if she's tested today, she would be clean. She's asking the court to help her change her life. Thank you.
All right, Ms. Bennett, anything else you want to tell me?
Just that I really want to get sober. I don't want to be out there putting other people at risk, and I think it got my attention now.
Well, you were like a wild woman there in the park. In fact, Daniel's on the phone when you're drunk, ranting and raving in the background. All right, Daniel, what would you like me to know?
Well, for clarification, I know we had spoken, I was thinking it was Meadow Lane, but it's actually Sweet Lake Trailer Park, so that's why the name didn't, you weren't familiar with it because I had the wrong park on the tip of my tongue, but it's Sweet Lake Park, and Melissa is the park manager. I had spoke to her, and as the court mentioned, a couple days prior to this, I was on the phone with Melissa, who stated she'd had a couple run-ins with Miss Bennett, and she called the police, and they didn't act with real interest, and she doesn't think they put a lot of effort. So I suggested that next time she sees her driving drunk, to follow her and make sure she uses safe and hands-free stuff and get on with dispatch so that the police can't lose her. I believe this is what happened, because that's actually how she was arrested. Was there was a caller who was following her, and the police caught up with her while she was on the phone with me 2 days.
I can't hear you. Oh, okay, never mind. I'll have a seat, please. Thank you. Oh, that's who you were. I didn't know. I didn't identify the names, so I didn't let you in. Sorry about that, Gilbert. Oh, now we squared that out. Just kind of sit tight, listen. There's not a lot, but there may be some from time to time. So thank you.
We need a little bit of time for the court so that we can show the court because I went ahead and I gave them the videos that I have. And when I say videos, Your Honor, they're little snippets.
Yeah. You cut them
Well, they're just, in this day and age, we use videos to.
all the time.
Currently have her on twice a week, Your Honor.
Okay. No drugs and no alcohol. Let's add that up. 75 plus 50 plus 150 plus 960 equals 1235. I don't believe we have any bond money in there. $5,000 cash or surety bond was posted. Concurrent with R&O.
And let's continue with the examination. The, you were saying that you had no objections to that, is that correct?
Yes.
That they are admitted?
Okay. So this time I'll play for the jury the videos that we introduced. So you were saying before the break that Dominic was able to say a few words, including hi.
You're gonna start with the number first, just
Okay, so
make
the
sure.
first number, 552 would be the
Thank you.
first one.
Hi. Hi.
553. Who's that? Do we hear in the back?
My sisters.
$548 next.
Two, three. Happy birthday to you. Woo! Happy birthday to you. Woo! Happy birthday, dear Dominic. Happy birthday to you. Woo!
What occasion was that?
That was Dominic's first birthday.
What day is his birthday?
July 26th. 2016. Mhm. So he'd have it was his birthday, so he'd
Hey. Come here, puppy. Dominic. Daddy, come on. Dominic, come on, Dick. Good job. Bye.
Whose voice is that?
my sisters.
And you were saying earlier about the birthday?
So my sister had told him his birthday was coming up, so he'd like everybody to sing for him days before his birthday and days after his birthday. So I think we celebrated his birthday for like a week. That was my sister singing happy birthday to him in my mother's bed.
I heard you said, was that Grizelda's voice in that last video?
Yes, on all those videos, that's her voice.
Would she, one of her terms of endearment, she would call him daddy?
Yes. Yes,
What-
that's
what
correct.
else would she call him?
Daddy, Papito, Dom, Cositas, Chunky Monkey. Yes, this video, the last one, he was just learning how to walk. That is at my house, right there.
What about the one on the slide at the park?
That's at the Father Magnobi Park.
At Father McNamara Park?
That's correct.
He's wearing the same shoes he was wearing the day he was killed?
That's correct.
And he was active running around. Is that before March the 25th?
Yes, that's correct. Everything changed after March 25th. He stopped walking.
Well, let's talk about March the 25th. Do you remember your sister asking you about the going that day, March 25th?
Yes. Yes.
You lent her your car?
Yes, that's correct.
We all know what happened on that day now through the trial. He was injured on his leg, correct?
Yes, that's correct.
You're a registered nurse, correct?
Yes.
Do you have any feelings about not being able to catch that injury? Do you have any feelings about not being able to detect that injury?
That is a pain of my own that I will have to live with the rest of my life. I would have never imagined that what I saw that day might have been anything other than what I suspected at the time. Like I've stated before, I originally thought it was a shot site, an injection site that he had received at the doctor's office, but thought that something so heinous would have happened to him. I feel I came to my reasoning using my observation skills and judgment, and this could have this maybe could have stopped if I would have stated I suspected otherwise, but without everything that has been presented here, there's no reason that I would have suspected otherwise and I would have felt otherwise.
Okay. Let me take you to April the 9th of 2018. Okay. 15 days after March the 25th. Okay. Do you remember your sister trying to or asking you for your car prior to April the 9th?
Yes. If I'm not mistaken, she asked for it to borrow it Saturday. I might be incorrect, but if I could refer to my texts or phone calls, I could confirm that.
If I may approach you.
Approach this way, please, first.
I'm gonna show her 485.14. waive your objection?
Yes.
And does it fairly accurately depict text messages that you had with your sister?
Yes, that's correct.
Let's talk more here with that because here we have the same objection. So it's a relevant objection. Yes, sir. Let's discuss it. So. if you- We gotta change that.
Your sister was killed on a Monday, correct?
Yes, that's correct.
And you had made arrangements to pick her up that Monday morning, correct?
Yes, that's correct.
But had she tried to borrow your car for Sunday as well?
Yes. I don't believe we could coordinate on time or something had come up.
So she reached out to you on Saturday. Do you recall?
Yes.
Looking at this line here, 13815. It says 3:28. The UTC time will make it 10:28 p.m. on the 7th.
Yes, that's correct.
So it's on the 7th, on Saturday, she was asking you to borrow the car for Sunday at 11 a.m.
That's correct.
Were you able to arrange that?
No, I don't believe so. If I'm not mistaken, we had a phone call after this text because I don't see any reply for me there on the bottom.
So on Sunday, who was she supposed to go meet Sunday morning?
Dominic's father.
Can you read that?
Yes. Hey, I was also going to ask if I can borrow your car so I can take Dominic tomorrow with his dad. Couldn't ask on the phone because Jaden is right here. Let me know. LMK, meaning let me know. It'll be early, he said. He works at 11, I think.
So your sister was going to see Anthony on Sunday.
That's correct.
And that didn't happen.
No, I like I said, I don't think we could coordinate on time. I don't believe I was home or I was going to use the car. I don't recall.
Okay. Now going to April the 9th, the day that your sister was murdered. Do you remember that day?
Yes.
Now, we already heard the testimony of how you spoke with Officer Gilbert Benavides, correct?
Yes, that's correct.
And I want to ask you what you did, if anything, when you found out your sister was the victim.
When I was told that she was dead,
Yes.
I was in my living room. I was surrounded by family. My parents were there, my brothers, my sisters. My husband.
Did you make it to the Father McNable Park?
I tried going before I found out to the McNamara Park. When the officers got there at my house, nobody was telling me anything. I knew something was wrong. So that's when I took my husband's truck and I left to go look for my sister at the park. I went where she told me she was going. I went to the Father McNable Park. I saw my car parked. I pulled up next to it. There was an officer there next to my car, and there was nothing. As far as my eye could see, everywhere around me, I couldn't see anything but some people jogging to the right. I kept looking. I kept looking to see if I would see something, anything. Nothing was there. You couldn't see anybody but the officer next to my car. He told me what I was doing there. I told him I was looking for my sister. He told me I couldn't leave. I wanted to leave after I didn't see anything to look further to the left, which is where the bike trail is at and the soccer field. But after that, he wouldn't let me go. He didn't let me leave in my truck. He just had me stay there. It was until 10 minutes later till my husband and my brother showed up, and then that's when he let me go.
What was your intent?
I was looking for my sister. I wanted to see her. I wanted to find her.
Did they let you see her as she was as the way she was found?
No, I did not see her.
Did you, as a sister and as a medical professional, did you want to see her?
Yes, I wanted to find my sister. I wanted to know where she was.
Do you want to see the way your sister was found?
Yes.
I'm going to publish exhibits that have already been admitted. They're graphic photos to Angelica Hernandez, who's requested to see her sister, how she was found. Sister there.
No, I wasn't. I returned to my house, and that is when I was told. After I got home, that's when I was told that my sister had been murdered.
How did you feel?
That is the biggest pain ever felt in my entire life. I felt I couldn't breathe. I felt it was just an intense pain. I felt angry. I didn't believe it. I needed to see my sister. I didn't believe it was true. I remember falling to my knees at the house when they told me, and immediately, like, well, to me, it felt like immediately after I got up and I started trying to shake it off, and I was telling the officer, you need to take me to where my sister is. I need to get my nephew. I need to go get Dominic. Dominic is going to be scared without my sister. I remember telling him he doesn't know his father. He doesn't interact with him. He's going to feel strange if somebody else is holding him. At this time, I'm already making sense who hurt my sister. And I'm telling, I need to go get Dominic. I felt so extremely betrayed because I was never told that Dominic was hurt. I still had hope in my heart that Dominic was okay. And then my mom hugs me and tells me, he's gone. Dominic is gone. And the officers tell me that Dominic has also been murdered. That just broke me. That was...
Did Grizelda have any other children?
My oldest nephew,
And what's his name?
Jaden.
How old was Jaden at the time?
Jaden was 6. He's 12 now.
How did Jaden find out about his mother?
At the time, we didn't tell him that day. We just couldn't tell him that day. He found out days later. My family is still torn to pieces. My dad and my mom, they couldn't come to bear the idea of telling him. So it had to be me.
How did you tell him?
I asked him to come downstairs, and I told him I needed to talk to him. And I was told that I couldn't say that mommy went to heaven or Dominic went to heaven. I couldn't tell him that they were in some type of eternal sleep. I needed to use the word dead. And so I told him that his mom and Dominic were no longer with us, and that they had passed away.
Where is Jaden today? Who does he stay with?
He lives with my mom. My mom has primary custody.
And he's 12 years old today.
That's correct.
Since the murders, do you all have the occasion to visit the site?
Yes, we do. My father visits the site where Dominic lay and my sister laid when they took their last breaths. He goes there every Sunday.
did you all do anything there to to memorialize their lives?
Yes, we have since then surrounded that hollow ground by placing either flowers for my sister or Dominic's side. The community, the neighbors, everybody usually takes toys to his side, or we'll see balloons in occasions, or pinwheels, toys, trucks, balls, all sorts of little trinkets.
I'm gonna show you what's been already offered and introduced to State's Exhibit 546. You can tell us where this is located.
Okay, that's not at the site
But is this at the
where,
park?
yes, this is at the Father Magnobi Park, where near where my sister had parked that day.
Give me
And
a
this
second. Okay, pull me off from the because if they're in the, thank you.
Who is this man right here?
Same objection.
That is my father.
I'm sorry. Yes, the objections are overruled. Your arguments from the earlier conversation will be incorporated into their objection. Thank you.
Who is this gentleman right here?
That's my father, Grizelda's father. And behind it, you'll see a tree. We have a memory tree that we go to that side to feel them closer.
Okay, and this is there at Father Magnobi Park?
That's correct.
Okay. I'm gonna show you State's Exhibit 547. What are we looking at here? Take your time, Mr. Hernandez.
This is where my sister was found. So where the trees at, directly forward, you'll see a road right here. And it's paved now. Before it was just a dirt road. And that's where my sister's body was found.
I'm gonna show you State's Exhibit 545. What is this?
So this is where Dominic was found, right between those trees. So it's open now, but at one time it was just the way you see the background. It was all the way to the front like that.
Well, I'll conclude with just asking you this question. You know now that the jury has found Mr. Ronald Anthony Burgos-Aviles guilty of murdering your sister and your nephew. How do you feel today?
I trust in our justice system, and I know you might not empathize completely or feel our direct pain. I feel once your life has been touched by such a black, sinister, heinous act, your core beliefs are changed somehow. Maybe even your faith is questioned. At least that's what I have gone through and continue to go through. But I trust in the justice system, and I know justice will be served for my sister and for Dominic. And my life will forever be incomplete. That hole in my heart will always be there. But knowing that I have done my very best to try to bring them justice, will have to serve as peace in this lifetime for me, because that is all I can do.
Thank you, Ms. Hernandez. Thank you. No further questions? Thank you. Any questions?
Ms. Hernandez, again, I'm so sorry. I'm not going to ask you any questions this time. Nothing.
Thank you. All right, Ms. Hernandez. You can step down and go back to business. Thank you very much.
Should be excused from the role.
Yes, she has been excused. She continues to be excused. You may remain in the courtroom if you'd like.
They called Mary Hernandez.
Mary Hernandez.
Your Honor, may we briefly approach before?
Approach, please. Hello, ma'am. I know that you've already been sworn in, yes? Yes. Please have a seat right over here.
Yes. Good morning, Ms. Hernandez. Good morning. And for the record, I'd like to, for you to state your full name. Mary Hernandez. And if you need to take a moment, we'll take a moment, and take it slow. Try to speak as clearly as possible. And I'd like to ask, you are, how are you related to Grizelda and Dominic?
Grizelda is my daughter. Dominic is my grandson.
And how many children do you have?
4.
Does that include Grizelda?
Yes.
And how many grandchildren do you have?
9.
Does that include Dominic?
Yes.
And you still include them when you say they are part of your grandkids or your children?
Yes. They'll always be with me.
Now I'm going to show you what has been May I approach you?
Yeah.
I'm going to show you what has been marked as State's Exhibit 554 and ask you if you recognize this photograph.
Yes.
Tendering to the defense, State's 554 and offering to.
$554.
Yes, Your Honor, but there's a problem with the number, I believe. The birthday video was 548.
Cindy, we're good? We're good with the number.
Okay, so then 554.
Admitted.
Now, will you, is this your, what is this a picture of?
This was,
554.
this was Mother's Day. These are all my grandchildren.
Your Mother's Day in 2018?
No, 20, I believe it's 2017.
2017, okay. And these were your grandchildren?
Yes,
And who's this?
that's Roger,
Younger than?
and that's Dominic, Brianna, Rocky, Becca, Jaden, Gali, Tristan, and JJ.
So this is,
That's Jaden,
and he is
Dominic's
older
brother, yes.
Now, can you tell us about Grizelda, the type of daughter she was?
Oh, Grizelda was my baby daughter. I was always overprotective over her, also of Angie, but more of Grizelda.
And what type of relationship did you and Grizelda have as compared to the relationship you have with Angie?
Grizelda was there when I went through my divorce. She was the strong person. Before me. She was a very strong person. She had character, but she would nonetheless would never let nothing bring her down.
And when you say character, are you like when you say it in Spanish, carácter?
Oh yeah.
And so what specifically do you mean by that?
Whenever she wanted something, she would get it somehow, but she was gonna get it.
Okay. And did she live with you?
Yes.
Did Jaden and Dominic also
Yes.
live with you? Now, did you and Grizelda were you all friends on social media?
We were.
Okay.
We were at one time, but come one day she wouldn't answer her phone. I kept texting her. She never answered, so I went into her Facebook and I put a telephone ringing. She got so mad she blocked me. She blocked me. Now, as of today, still, she needs to see everything that she's gonna post there to be approved by her. But that's why she blocked me.
And do you remember when Grizelda told you about being pregnant with Dominic? Will you share that story?
Yes. We were sitting at the table at my house, and she comes and gives me a blue cupcake and puts it right in front of me. And I had all my grandkids there. And I tell Grizelda, Mom, why did you bring me just one cupcake? All of my grandkids are here. So I just got it and I looked at it and I told her I'll eat it later. And I put it to the other side. But the strange thing that none of my kids asked me for cupcake. So when nobody was there, I went to reach for the cupcake and I took it off its container. And it said, it's a boy. That's how I found out she was pregnant.
And did she tell you who the father was?
Not there. When we were eating, my two sons and my daughter, we were sitting at the table. And I asked her who the father was. And she gets her phone and she opens it. She goes like this. And she closes. And she says, that's it. That's all you want to know about him. I never saw his picture. Just she passed it very quick. I don't know.
So you didn't, if you would have seen the father, did you have a name at this point?
I believe she told us that his name was Anthony.
So if you would have seen Ronald Anthony Burgos-Aviles back in this is when she was pregnant, 2017, would you have recognized who he was?
No.
What about in 2018? Did you ever know what his face looked like or what he looked like?
No.
Okay. And you were in the courtroom when there was some testimony regarding a text message where Grizelda was told that Ronald Anthony Burgos went to your work, and that you saw him. Do you recall that?
Yes.
Did you ever see Ronald Anthony Burgos at your work?
I was surprised when I heard it here that he had gone to my work. I don't recall seeing him. I see hundreds of people, thousands of people. I had never seen.
And did you help Grizelda with Dominic and Jaden?
Yes.
What kind of help did you give her?
Since the beginning, she told us that Anthony was not going to come into the picture, that we were going to be able to help her. So me, my daughter, and my sons, we helped Gray. We helped her with the Pampers, the diapers, the clothing, the shoes. I'd sometimes give her for the daycare. Clothing for her, clothing for Jaden. I would support her.
And what kind of, how would you, how would you refer to Dominic?
Cositas.
You did?
I would call him Cositas.
What about Grizelda? How would you refer to Dominic?
Gray would call him Cositas also, Daddy. Chunky Monkey. My handsome.
And when you say Gray, you're referring to Grizelda.
Grizelda.
And did you ever go to the daycare where Dominic went?
Yes.
Attended?
Mm-hmm. Yes, I did.
And so you're aware of how she planned to pay for the daycare?
Yes, as she started getting financial aid, she would go with her payments from there.
Do you recall when Dominic had an injury on his leg?
Yes,
And the effect it had on his attendance at daycare?
oh, yes.
What effect did it have?
He was walking at that time when he was in daycare. March 25th, when he had that injury, he could no longer walk. He would drag himself until they told him at daycare that they couldn't be carrying him. He had to be carried to take him from one place to the other.
Now I'm going to show you, Your Honor, may I approach the witness?
Yes.
I'm going to show you State's Exhibit 541 and 543 and ask you if you recognize this photograph
Yes.
and then this USB. 541 and 543.
Not 541.
541 is good, but not 543.
So then let me change to 547. Let me
What's the
skip.
next number over there?
Let me just do 550.
The next one has to be 555.
555. And 555. So correction for the record, it is 541 and the USB that is marked 555.
Yes.
Does it also have your initial?
Yes.
Tendering to the defense and offering into evidence State's Exhibit 541 and 555.
Maybe we touch briefly on it.
You're offering both.
Yes, Your Honor.
Thank you.
State's Exhibit 541. Was this received or was this made by the children when he wasn't attending school because of the leg injury?
Yes.
I'm going to show, maybe publish stage 555, Your Honor.
Okay, go ahead.
Before you publish that. When you went
Oh,
to,
I'm sorry. You want to push that button on here? So you can go ahead and do it if you'd like. Just put your state, I don't know if it's a state or plaintiff computer or laptop. I don't know. Thank you. There it is.
now, on the day of the injury on Dominic's leg, did you join or did you go to the hospital with Gray and Angelica?
Yes.
And so you were in attendance when the doctors, or they were going to tend to Dominic and the leg?
Yes. I believe I left work because I was so worried about Dominic. And when I get there, something bit him. And I reached to Gray to get to Dominic. And Dominic gives me his hands to pick him up. And he says, "Owie, mama." And he points to his leg. And I carried Dominic. And I tell her, he better not have hurt Dominic.
When you say he, were you aware that Gray or Grizelda had met with Ronald Anthony Burgos earlier that day?
Yes, she told us the day before that she was going to go meet him, that he wanted to meet Dominic. At that time, I was mad. Dominic was already 18 months. How would he want to come into his life after he didn't see him crawl, take his first bottle, take his first steps, go to daycare?
And had you shared this with your concerns with Gray or Grizelda?
Yes.
I'd like to publish, Your Honor, State's Exhibit 555. And this is a video of what does it show in this video?
It's not up here, hold on.
Oh.
It's on mine, but for some reason it's not on. All right. Go ahead, publish.
He was crawling. He could no longer stand. And as you can hear him, he would have to tilt to the other side because his leg would hurt.
Which leg was it that was hurting him, that had the injury?
I believe it was his left leg.
Where was this?
This was at my house, Gray's room. We tried to make him more comfortable.
Now, before this injury. And did he enjoy going to the daycare?
Yes,
Would you sometimes take him?
Gray would be mostly the one who would drop him off, but there was times where I would walk him in and he would run to his classroom. He had this like a little puppet, but it was a Tweety. And every time that he would walk in, he would get that little Muppet Tweety and put it where his name was to let them know that he was present.
You mentioned that that was his favorite one.
That was his
that you
favorite Tweety.
witnessed.
Yes.
And the little, he was a little Tweety bird, Muppet.
Yeah.
Or puppet. And there's also you have a pet or a bird named Paquita.
Yeah, she's my Amazon gray parrot.
Okay. And you also mentioned a story about Paquita and how she would, that she speaks, correct?
Yes.
And how, explain to the jury, I guess what Paquita did one time that made you all think that there was other people in the kitchen.
Paquita mimics all the words that you say. She would, Angie and Grizelda would be talking in the kitchen very, very quietly, but Paquita hears everything. So as soon as I would come into the kitchen, Paquita would start doing it. And I knew that they were up to something because she already let them know that something was good. She'll start mimicking everything. And one day, Dominic, I told him, don't put your finger in the cage. She's going to bite you. He kept doing it until Paquita bit him. He got so mad because we laughed. And he went up to the cage and he shook Paquita out of her tree limb. He was so mad at her.
And is there a significance whenever you see any feathers?
Oh, yes. Whenever I see feathers, red cardinals, that means our angels are close to us. One day, Jaden was in the restroom. In my restroom, you have to go all the way to the kitchen, past the hall room, down to my master bedroom. Then you go into my restroom. Jaden was there and he says, Grandma. And he picks up his feet and he says, look, I think Mom's here. There was a feather in his toe. I believe all those. Even when a cardinal comes, I know my angels are with me.
Now, before, I want you to share some of the good memories and fun memories that you had of both Grizelda and Dominic before the injury. And I'm going to show you, and also I want to ask, do you remember what Jaden was like with Dominic?
Yes.
Describe that for the jury, please.
When Gray told us that she was pregnant, Jaden was so happy because he always wanted a baby brother. He would always pick up Grizelda's blouse and kiss her tummy. Anytime that Grizelda was cooking, he would always come through the back hug. Almost done. He almost cooked, Mom. That meant to him if he was ready to be born.
May I put you on it? I'm going to show you, I hope the numbers are right, states 542, which is a USB.
Mm-hmm.
It's asking you to recognize
Yes.
this one, and you also have your initials.
Yes.
And states exhibit 544.
Yes.
I believe, tendering to the defense for inspection and offering it to others.
With the same as before. All right. Then I'll incorporate that into your.
And specifically, just for the record, it was for 542.1, the objection, and 544. Thank you. I'd like to begin with State Exhibit 544. So Jaden was 5 when Dominic was born?
6.
How are you putting it on?
I don't know. I don't know.
And this was that Grizelda, Gray's voice?
Yes, that's Grace's voice. That's Jaden and Dominic. He would always try to help his mom with Dominic.
And changing the diaper was
changing the diaper, getting his bottles, getting his snacks.
And some of the on State's Exhibit. State's Exhibit 542. And Dominic was a child who was.
Who did the? Who did the math? You did the math? It was you? Who did the math? You did the math? It was you?
Now, she did Grizelda earlier. She was a woman of character, and she also liked to joke around. And
yes, she liked to joke around a lot. Sometimes she would get on my nerves, but that's her way of teasing me. And now I wish she would still do that.
Now, on this next video, this was before Dominic's injury. Where was this? Do you know?
I believe it was a party, maybe, where she was invited at that trampoline. I believe altitude.
And this was him true to form?
Yes.
Running around?
Yes. He loved it.
Now, because they lived with you, all three of them, Gray, Dominic, and Jaden, things changed after April the 9th. I want to direct your attention to April the 9th. And I'm going to show you what has been marked as State's Exhibit 87.3, and these are excerpts from the Facebook. Do you recognize this? It starts back.
Yes.
Tendering States Exhibit 87.3. It states Exhibit 87.3.
Be admitted without objection.
And just by way of reference, I just want to confirm. Today we introduced to us Mary Hernandez.
Yes,
Mary Garza.
it's my maiden name.
So these are authored by you.
Yes.
Now I just want, can you just look at the date and time of this timeframe of this messenger messages? This was what date?
April the 8th,
2018.
2018.
And it's saying that there was an image. Now I'm gonna show this image to the jury. Did you send that message?
Yes.
Or this picture? That's you?
Yes, that's my last picture with Dominic.
Let's go through the discussion that you had with Gray. Now, this was Grizelda,
Mhm.
and what did she say?
She says cositas de mami, LOL, which means laugh out loud.
And then,
She's asking me there, how is he, mom?
and then you responded.
He barely woke up.
You also responded.
And I responded, he's fine, not necio. And not necio mean that he's not grouchy. Oh, okay.
This one is it's partly up here, but so I'm gonna, who authored that one up there?
Grizelda,
So Griselda says,
you let me know how he is in a little while, mom. And then she says, si no me lo traigo.
and then you responded?
I'm sorry.
Say it, repeat that.
Si no me lo traigo.
Interpreter.
If not, I will bring it.
And then I say, he'll be fine. Then Griselda answers, ándale, yo voy por él, ma, LOL.
Okay, Mom, I'll go for him. Laugh out loud.
And then what did you respond?
I send a picture to Gray. That little monita that says no.
Oh, you sent this saying yo.
Yes.
This one. Okay. And then?
And then I say, it's grandma time. She says, LOL, ay ma, ha ha ha. Great.
Now this is a different day.
Yes.
Now, this says UTC time 14:54.
Mhm.
What is it? What you tell Griselda on? What's the date?
On April the 9th, 2018.
I know it's 9:14, but I need the, and so for the record, Your Honor, under UTC conversion, it would be 9:14. There's an exception. And so at 9:14, on April the 9th, what did you tell Grizelda?
I asked Gray, take a picture of Dominic leg as it is right now.
Do you know where he was at this time?
Excuse me?
Do you know where they were at this time?
Yes.
On April the 9th?
Yes.
Where?
They were at the Father Magnable Park.
And then,
She didn't reply, so I sent her another one. How's Dominic?
and the time says UTC time?
15:25.
And you- and the next one?
It says, great. I asked her, great, everything okay?
The same date?
On April the 9th, 2018, at 17:46.
And if you subtract 5 to that,
That would be 10.
5 from 1746?
12:46.
And you subtract 5 from 1525?
10:25.
So these are the times that these were sent.
Mhm.
And this was on April the 9th.
April the 9th, 2018.
Now, before receiving the call from the Laredo Police Department, where were you?
I was at my work.
Where's your work located?
It's on Shiloh Drive.
And you had already been sending messages to her, and she was not responding. Tell me what happened that caused in that morning.
On the first message, Gray didn't answer. So I kept calling her from my work phone. I called her about 10 times. She never answered. I called my daughter, Angie, to please call Gray because she wasn't answering the phone and this was not Gray. Even if she were to be busy, she would always answer my call.
And did you remain on there until, who contacted you so that you could go to your house or to Angelica's house?
Nobody. I just had that motherly instinct because I was facing Shiloh. Suddenly I see cops passing through. I see ambulances. And there was no other way they were going anywhere but Mines Road. As a mother, I had that mother instinct that something could have happened to Gray. First, she wasn't answering my calls. And I just had to leave work. I just left work. And I started to proceed to Father Magnable Park when Angie calls me to meet her at her house.
And had she told you what, why to meet her in her house, or you
No.
just didn't know? Okay. And in your home, who does Jaden live with now?
He lives with me and Ricky.
Do you remember, or can you describe for the jury the relationship that Jaden had with his mom, Grizelda?
That was Jaden's mom. First of all, it was his mom. He loved her so much. And he misses his brother too.
And at the time of Gray's and Dominic's death, what were Jaden's sleeping arrangements?
Gray's room is right across my room. So he would sleep with his mom. But sometimes Jaden would go to sleep with me to watch TV later. And he would fall asleep with me in my room.
After the passing of his mom and his brother, how did it affect Jaden?
It was very hard for him to go back into his mom's room. So at 6 years, he's sleeping with me. He's afraid of the dark. He's afraid to be alone. So I had to sleep him with me.
And what about on occasions that I believe you travel for medical purposes out of town?
Yes.
And how have you modified your arrangements or travel arrangements because of this?
Because of this, Jaden has felt very insecure. He wants to know exactly where I'm at. What time did I leave? What time did I come back? Why I didn't answer my phone when I travel out of town from doctor's visits. I need to be back that same day, or he's coming with me.
And the month of April, how do you, on April the 9th, after you found out that they passed, how did that impact you?
My whole world came apart. I couldn't believe it, especially Dominic. It's been very, very, very hard. It has totally changed our lives.
Do you and Jaden ever go into her room?
Yes. Jaden asks, Grandma, can we go into Mom's room? That room is locked. Everything is still the same the way she left it. But sometimes Jaden wants to go into her mom's room. So I go with him. He just wants to be there for a little while. He goes to his mom's bed. And he goes like this on her bed, just looking at the ceiling. I don't know what crosses his mind. But it has impacted him so much.
Has he found a way to cope with that?
Yes, a little bit. He's tried going into karate classes, but no. Now he's in band right now, and he'll be going into football.
Now I'd like to ask you to share the story that you would like to recall that brings you peace when you recall the peekaboo game that you played with Dominic.
That was just one of the games that, as you sit in my kitchen, there's this door in the hallway next to his room. He would open the closet door and he would go, "Peekaboo, mama." Now I sit there and I look towards that wall, but there's nothing there. There's nothing there, just memories. Memories are all that I have.
Mrs. Hernandez, I'm so sorry for your loss. I have questions for you.
Thank you.
For lunch right now, it's 1:15. I'm sorry, 12:15. Let's see if we can get back by, just get back by 1:30, and then let's see how as soon as everybody's together, we can get started right after. Okay, thank you. Remember that you're still under the same instructions that I gave.
Please rise for the jury.
I'm just going to play that back because I didn't catch what time. Let's see. Okay.
Right now it's 1:15. I'm sorry, 12:15. Let's see if we can get back by, just get back by 1:30, and then let's see how as soon as everybody's together, we can get started right after that. Okay, thank you. Remember that you're still under the same instructions that I gave.
Okay, so we've got an hour and 15 minutes. Let's see, what have we got?
So yes, I guess what you're telling me ahead of time, Judge, these are the witnesses that we intend to call, just so that I can sort of, at the same, I appreciate that. That way, I can sort of think of our schedule for the rest of the day and tomorrow. And you were mentioning,
We have one more family member.
I'm sorry, Detective Garcia.
Yes, and we have Josh Nunez, her first cousin, who identified the body.
Okay.
He's as a family member. We have Jose Luis Macias, mental health
Yeah,
specialist.
you talked about that. Yes, sir.
We have Raimundo Garcia, lead detective. What I stated in my opening statements that we would be bringing him to talk about some other aspects of the investigation.
That were not brought in during the first phase.
Correct. We didn't bring them in the first phase. We're bringing them in now. And then, based on state's defendant's exhibit 7, that was admitted,
Which are the defendant's medical records.
his medical records.
I think it was in particular, your emphasis is on Dr.
Oscar Bettis.
Bettis' records.
Yeah, so he published to the jury the descriptions of Betterment and phentermine and
Testosterone.
testosterone. That he was taking a combination of medications. And so,
Well, actually, it was just published without any word.
no, what he published were certain the
Right. What I'm saying is when they were published without any sponsor. So it was just publishing, and then it wasn't until his opening at after the guilt innocent phase that he mentioned that something to the effect about you're assuming that not assuming, but since opening is what the evidence will show, that in fact that something to the effect about the defendant being poisoned by his own doctor or something like that.
So
So as a result of that is what you want, I'm sorry, you want to do what?
Okay, so making the connection between defendant's exhibits 7 and him being Mr. Ronald Anthony Burgos-Aviles being prescribed the phentermine and testosterone. And then Defense Exhibit 7 will, for that.
I don't think he said Defense Exhibit 7 will show that. I think he
No,
just said.
He said,
right.
put a slide that said that he was poisoned by these combination of these two medicines that he was prescribed. He was
Right.
poisoned by his doctor.
Right.
So with that said, we believe that opens the door now to bring in a Dr. Dagoberto Gonzalez, who I contacted on Friday after Mr. Boggs' argument to rebut that claim that testosterone and phentermine will poison or result in psychosis. His claim in opening was that combination caused psychosis. Dr. Gonzalez has a close to 25-year physician, OBGYN, and also does hormone therapy and replacement in Laredo. also a speaker on the topic and also is a mentor to physicians in Texas and the administration and prescription of fentanyl and testosterone. And he will come and anticipate be able to speak as to his practices. And
So he routinely prescribes this?
he prescribes it to men and women since 2013. And is
Okay.
also
So let's hear from you, Mr. Boggs, on that issue. My initial impression, like I said earlier, Mr. Felonies, is that we should wait for that evidence to actually come in. Right now, we do have the records, but there has been nobody that has testified that combination of drugs does anything to anybody.
my
So, and he can't actually argue that. If everything stayed the way it is right now, Mr. Boggs would not be allowed to argue that at the time of argument because there is no reasonable inference that could be made from merely having his records admitted. So unless somebody else came and made that connection, would that argument be able to mimic? That's where I'm at right now, but let me hear from Mr. Boggs on that issue.
Well, if I could say one more thing, that I respectfully would say that the inference that he made, and by introducing this document, I would be able to ask Dr. Dagoberto Gonzalez his professional opinion as to the records that he's now reviewed, that if in his opinion they, if the doses, if protocols, if the medications themselves interpret the medications in making his giving his opinion as to the treatment that Lucas was receiving. Not so much attacking Mr. Boggs' claim, but being able to interpret the documents that we have here. And I believe that the door's been open to have Dr. Gonzalez come in his opinion, interpret these medications, the milligrams that were prescribed.
To say what, though? To be able to say what?
say that in reviewing the notes, the physician notes the amounts of 37 milligrams that he was being prescribed, 37.5, the testosterone, what taking testosterone by itself, taking testosterone with fentanyl together, what are the practices, the accepted practices in the medical profession. He will testify that he prescribes those medications.
So, but to what end is what I'm actually
Well,
getting.
to the end that they're perfectly normal, and that
But,
psychosis doesn't
and
result.
to rebut what?
Well, not to rebut, but to interpret, for now, is.
In other words, why would it be relevant evidence and punishment on your part of the case?
It would be relevant,
In other words, would it go to, the issue number one? Would it go?
it would go specifically to special issue, question number 2. That the jury's not left with a false impression, which is what we contend it is, that he was suffering from some mental disease.
But no one has actually said that yet.
No, but the inference can be made without somebody interpreting, well, what happens when you take testosterone with fentanyl? What happens when you take testosterone? What happens if you
And
take
do you
fentanyl
believe,
by itself?
do you believe that that's a question that's going to be left in the jury's mind, despite the fact that, assuming for a moment that no one testifies?
Yes, it is.
Oh, let me finish my thought though.
Okay.
Without anybody coming in to testify that in fact, as Mr. Boggs promised, that they would hear from somebody saying, maybe not promised, but that he would hear from somebody, that they would hear from somebody to say that in fact that combination of medication would play some sort of role in somebody's mind or whatnot. In other words, if no one testified to that effect, then what would your doctors? In other words, how would Mr. Boggs be able to argue anything at the time of argument, because there is no evidence other than state defendant number 7, if it is number 7.
Yeah, this is
In other words, Mr. Boggs wouldn't be able to make that inference at all without somebody saying whatever with regard to that.
Correct, but I do believe that bell has been rung.
You say
And
because he
also,
opened it.
He opened it.
I'm sorry, because he opened on it, is what I'm saying.
He opened on it. He was riding on the coattails of defendant's exhibit 7, leading the jury down that path.
All right.
We're also able.
Well, why not wait till it comes in then?
Under factors to consider for capital murder
Mhm.
cases, mental state is a factor that the jury can consider. I believe that the state has the right at this point, because it was not an issue, but now that the fact has come out that Mr. Burgos-Aviles.
But there is no fact that came out. What is
Well,
it?
the facts come out here that he's been prescribed medications,
Right.
testosterone, phentermin, and
But that alone means what?
well, that alone can mean that, well, he was on drugs. He was taking some sort of, some medication, and it wouldn't have been an issue
Mhm.
until he gets up in opening and says, and puts a slide, says that my client was poisoned and had psychosis. It wouldn't have been an issue,
Mhm.
but now it is an issue.
Mr. Boggs.
Judge, I think Your Honor nailed it on the head, which is that just because I opened on it doesn't mean that I can argue that in closing to the jury. In fact, without presenting some evidence to interpret defense exhibit number 7, I would be precluded from arguing that to the
You would be
jury.
precluded,
So-
but and the DA would be able to say, Mr. Boggs told you that he was going to bring somebody here to tell you that he was poisoned, that this and this was at effect, and he did not. He wasn't. No one came in to tell you anything. He'd be able to argue that, would he not?
He would, yes, sir. I believe it's premature.
Well, that'd be a good argument that he lied to the jury. That's fine.
Yeah, I'm going to wait until that comes in, and then we'll take it from there. So
Okay.
have Dr. Gonzalez on standby in case. By the way, Mr. Boggs, your expert on that issue, I looked at your expert list, and there was somebody there on your list that could potentially meet that criteria, and I'm not sure exactly who that one was, but I thought I saw somebody on your list with some. Tell me who that is, if in fact he comes in.
Judge, we have a
He or she
disagreement
comes in.
over how to pronounce his name. I believe it's Dr. Gupta.
That's exactly who I thought you may.
We still not have received any CVs or reports.
I believe we filed it with our notice. I'll make sure. I just received Dr. Gonzalez's
CV.
CV. I will make sure that they get Dr. Gupta's. I apologize.
But he was on the list, was he not?
He was on the list from May, I think, or even before. He was timely filed, I think, April 11th.
Well, we need to have his.
He has been on
his-
the list for some time.
They should have had his CV.
And we also don't have the CV for Dr. Cunningham.
All right, can y'all get together on that?
We'll get that. We were just-
Not sure why that hasn't happened, but make sure it gets that done.
Now, along the same lines, what is the court going to say about Jose Luis Macias? We would-
Observation?
Yeah, he does those, court's familiar with his assessments, right? When he goes by and talks to the defendant and does his assessment.
Mr. Macias, I understand, well, there he is over there in the back. And I only identify him because I've dealt with Mr. Macias before on many occasions on special issues dealing with our own, stuff that we do throughout as a result of CCQs and magistration issues and things of that nature that him and the rest of his colleagues there at the jail deal with it with the medical personnel. But in any event, what you're saying is that his observations will be with regard to what he observed on the day that the defendant came in, and how he looked.
And the forms that he fills out.
Oh, and the forms that he fills out, because they ask him questions when they do the forms, under, I'm not sure what Senate bill it is anymore, but a lot of things changed throughout the last 4 or 5 years with regard to when you arrest somebody and what are the things that you look at, all those forms were put together for us, and some of them we did on our own. And so in any event, we did a mixture of things. So as a result of that, they get interviewed. You know, inmates get interviewed, and they get asked questions with regard to their, you know, where they're at. You know, regular, I don't want to say CCQ interviews, but in any event, yeah, they're dealing with whether somebody's going through something in their minds and or in their lives that may require further attention, further examination by somebody in the mental field. And normally it's for purposes of determining whether somebody should be given a PR bond or not, right? So unfortunately, in this situation, they wouldn't have qualified for it anyways, but we still went through that, I'm assuming, through that particular, the jail is still obligated to go through that particular questioning. This is something I know because I've dealt with Mr. Macias in that area in many occasions. It still should, I don't know if they did this with Mr. Aviles or not, Burgos-Aviles, but I'm sure they did. And so there is some information in that that would say how he answered particular questions with regard to his state of mind, things of that nature. So that's why Mr. I suspect that that's why you want him here.
Yes, that's why he's here. He can testify as to the demeanor, his effect, Mr. Burgos' effect.
I don't think that, I don't think that has to wait for anybody. What do you suspect of?
Judge, we received notice of this, I believe, yesterday, Saturday. I apologize.
Do you have the documents that you're going to show through him?
He's had them the whole time, but yes.
Okay, can you all just specify what documents? Maybe you can chew over that over lunchtime, and then we can talk about this thing again. Who are you going to call first after lunch?
I was gonna call Raimundo.
All right.
Or not Josh.
Okay, well, let's trade those documents, even though you probably already have them. Let's make sure they know exactly which ones they are, and y'all can take a look at what that is. Thank you.
Ooh. And we have the wall of ham. Going to take a quick break here, and when we come back, we'll do the Darrell Brooks pleading guilty on his assault of Erica Patterson. So be right back. Oh, Holly, you need to check out the Waukesha parade massacre trial. Darrell Brooks, as he insists on being called, is a sovereign citizen who insisted upon representing himself for the murder trial. There were, I think it was 6 people killed and something like 60 others that were injured. Oops, just a sec. Okay, so it's the wildest trial that I've ever seen, and the judge has the patience of a saint. They have to keep putting him into the other courtroom so that they can mute him because he won't shut up, and he throws temper tantrums and it's just unlike anything that you've ever seen. And who knows, maybe we'll do a flashback trial because that one's just so interesting. Okay, let's go over to the reason that he had he got into the oops, let me try that again. The reason that he was upset that day is he had a fight with his on and off again girlfriend, Erica Patterson, and he was fighting with her, tried to run her down with his car. Then he drove up the parade route and was trying to hit as many people as he could. So anyway, this is let's see. This is him. He is he had says plead guilty to the fire charges. So I don't know anything about a fire, but let's listen to it because this should be good.
Yeah, slowly but surely, I'm down to like 4 cases here. So yeah, to just run around there. I think I've started to get the grasp of how their logistics work. So all right.
This is State of Wisconsin versus Darrell Brooks Jr., case 20-2550. Appearances.
State appears by Jacob Core. Good morning, Your Honor. Darrell Brooks appears by Attorney William Rakestraw and Attorney Robert Hampton. Good morning, Your Honor.
Good morning. The record should reflect that Mr. Brooks is actually appearing via Zoom from Dodge Correctional. We were on the calendar for a jury trial today. The court was contacted by the parties indicating that they had a resolution in this matter. And so we converted the jury trial date to a plea date. Mr. Core is in compliance with any required victim notification.
Yes, Judge.
And what is the plea agreement?
Judge, counts 1 and counts 2 are going to be dismissed outright. During the pendency of this case, we were unable to locate the essential witnesses as to those 2 counts.
given that we can only proceed on count 3, that is the count that he's going to be taking responsibility for. As to that felon in possession of a firearm, the state is going to make a recommendation of prison, leaving the amount up to the court.
Defense counsel, is that your understanding of the plea agreement?
It is, Your Honor.
Mr. Brooks, were you able to hear that?
I can hear the gist of it. It's kind of low over here on my end. I have it turned up, so
Okay.
I can hear it, but not as good as I would like to. But
Okay, are you able to hear me?
yes, sir.
Okay, so what Mr. Kaur said was the plea agreement was that counts 1 and counts 2 are being dismissed outright because the state has been unable to maintain contact and cooperation with the necessary witnesses. So those 2 counts are being dismissed outright. The plea agreement is that you will be entering a plea of guilty to count 3, which is the charge of felon in possession of a firearm. And at sentencing, the state is going to recommend a term in the Wisconsin State Prison with the length and any details of that left up to the court, with you and your lawyers free to argue for what you believe is appropriate. Is that your understanding of the plea agreement, Mr. Brooks?
Yes, sir.
All right. The first thing I need to talk to you about, Mr. Brooks, is you're appearing today via Zoom from Dodge Correctional. As the defendant in a criminal case, you have the right to be physically present in the court when the judge accepts your plea and enters a judgment of conviction. You also have the right to waive or give up that right and agree to proceed via Zoom. So understanding, Mr. Brooks, that you do have the right to be physically present in the courtroom, are you willing to waive that right and agree to go forward today via Zoom?
Yes, I am.
Mr. Brooks, has anybody in the world threatened you in order to get you to tell me that?
No, Your Honor.
Mr. Brooks, have you used any drugs or alcohol today?
No.
And Mr. Brooks, has anybody promised you anything in order to get you to waive your right to be physically present in the courtroom?
No, Your Honor.
Have you had a chance to talk to Mr. Rakestraw and Mr. Hampton about this?
I talked to Attorney Rakestraw, not Attorney Hampton.
And was Mr. Rakestraw able to answer any questions you might have had about this?
Yes, he was, Your Honor.
All right. Mr. Rakestraw, have you talked to Mr. Brooks about his right to be physically present in the courtroom?
Yes, Your Honor.
And do you believe that his decision to waive that right is being made freely, voluntarily, and intelligently?
It is, Your Honor.
Mr. Brooks, I am going to accept your decision. I believe that you do understand your right to be physically present in the courtroom and that you have agreed to waive that right and go forward today via Zoom. Mr. Brooks, I am going to ask you to do a couple of things. One, if you have a problem hearing anything that's going on in court today, you need to raise your hand, do something to get my attention so that we can address that. Two, if you were physically present in the courtroom today and you had a question for your lawyers, you would be able to just lean over and ask them. But because you're appearing today via Zoom, that's not a possibility. So if you have a question that you need to ask your lawyers, again, you'll need to get my attention. I can open up a breakout room. They'll log in on a device and they can answer that question. Are you able to do that for me, Mr. Brooks?
Yes, sir, Your Honor.
Thank you. All right, Mr. Brooks, count 3 in the criminal complaint charges you with felon in possession of a firearm. That is a Class G felony. The maximum penalty for that is 10 years in prison and a $25,000 fine. That 10 years can be broken down as 5 years of upfront prison time, followed by 5 years of extended supervision. Again, because it's a felony offense, you will lose your right to possess a firearm. That is a lifetime ban, and you will lose your right to vote until your civil rights are restored. Mr. Brooks, understanding those are the maximum penalties, what is your plea to the charge of possession of a firearm by a felon? It's charged in count 3 of this information, which allegedly occurred on or about July 25th of 2020 at an address in the 4000 block of North 19th Street in the city and county of Milwaukee.
I plead guilty, Your Honor.
Mr. Brooks, your lawyers filed on your behalf a plea questionnaire and waiver of rights form. Well, do you have questions now or anything that you feel like you don't understand about the information that's on that form?
Maybe one or two questions.
Do you know what, I guess, can you tell me what you have questions about?
I don't, it was maybe like a week and a half or so since we talked, so I can't remember exactly what it was. I just recall it was maybe something minute or minor. I just wanted some clarification on.
All right. So, and did they print out a copy of this form for you?
No, I have no copy of it.
Okay. So, we'll start, the form tells me that you're 40 years old and you've completed 12 years of schooling. Is that correct?
I've received a GED, yes, Your Honor.
Okay, so it says that you do have a high school diploma, GED or HSCD. The form also says that you understand the English language and that you understand the charges to which you are pleading and that you are not currently receiving treatment for a mental disease or a mental illness or disorder, and that you have not had any alcohol, medication, or drugs within the last 24 hours. Are all of those things correct, Mr. Brooks?
Yes, sir, Your Honor.
And do you have any questions about those items?
No.
All right. Then the form goes on. It's got a portion that's labeled constitutional rights. And that part of the form states that you understand by entering that you're giving up the following constitutional rights. You're giving up your right to trial. You're giving up your right to remain silent and understand that your silence could not be used against you at trial, that you're giving up your right to testify and present evidence at trial, that you're giving up your right to use subpoenas to require witnesses to come to court and testify for you, that you're giving up your right to a jury trial where all 12 jurors would have to agree that I am either guilty or not guilty, and that you're giving up your right to confront people who testify against me and cross-examine them, and that you're giving up your right to make the state prove you guilty beyond a reasonable doubt. Do you have any questions about those items on the plea questionnaire and waiver of rights forms?
Say it again, Your Honor, I'm sorry. The
Do you
last
have
part.
any questions about those constitutional rights that you are waiving or giving up as a result of entering your guilty plea?
No, Your Honor, I'm sorry about that.
That's no, don't worry. All right. And then the next part of the form says that you understand the elements of the crime that you are pleading to. And for felon in possession of a firearm, there would be two elements. The state would have to prove that in Milwaukee County on that date in July of 2020 that you possessed a firearm. And they'd have to prove that prior to that date, you had been convicted of a felony offense, and that felony remains on your record and had not been reversed. So did you and Mr. Rakestraw discuss the elements of felon in possession of a firearm and how your conduct met those elements?
Yes, Your Honor.
And did you understand all that?
Yes.
The next part of the plea paperwork says that you understand the maximum penalties, which is that 10 years imprisonment or a $25,000 fine or both. Do you understand that?
Yes, Your Honor.
The next thing on the form talks about the fact that there is no mandatory minimum penalty for this offense, and also that there's no presumptive minimum for this offense. Do you understand both of those items?
I guess I do. I'm little.
All right.
With mandatory.
Let's go over that a little bit more then.
Okay, I'm sorry.
Sure. No, please. And I appreciate you asking these questions. So for some offenses, and actually for this offense, there used to be what's called a mandatory minimum penalty. So that would, if there's a mandatory minimum penalty, that would basically take away the judge's discretion to sentence you to anything less than that mandatory minimum. But currently, for the offense of felon in possession of a firearm, there is no mandatory minimum penalty, which means the judge has complete discretion to sentence all the way from a fine or probation all the way up to the maximum penalty. But there's nothing that requires the judge to, there's nothing that limits that ability of the judge. There's no mandatory minimum sentence. Does that make sense to you, sir?
Yes, sir, Your Honor.
Okay. And then the same way there's no mandatory minimum, there's also no presumptive minimum penalty, meaning, again, there's not a presumption that the judge has to impose at least X as a sentence. So basically in the current state of the law for this charge is that the judge has complete sentencing discretion. Do you understand that, sir?
Yes, Your Honor.
All right. Then the next part of the plea agreement paperwork talks about understandings, and it tells you that the judge can impose a lesser sentence if the judge states appropriate reasons. It talks about the fact that if you're placed on probation and probation is revoked, if your sentence is withheld, the judge could sentence you to the maximum penalty. Or if a sentence is imposed and stayed, you'll be required to serve that sentence. Do you understand that?
Yes, Your Honor.
All right. Then the plea paperwork talks about the fact that if you're not a citizen of the United States, that your plea could result in deportation, the exclusion from admission to this country, or the denial of naturalization under federal law. Do you understand that, sir?
Yes, Your Honor.
And then it talks about the fact that if you're convicted of a felony, you may not vote in any election until your civil rights are restored, and that it is unlawful for you to possess a firearm. Do you understand both of those things?
Yes, Your Honor.
All right. The next two things don't really apply to the offense that you're pleading to today, because it discusses a body armor restriction for a violent felony, and also the consequences of a serious child sex offense. So those don't really apply here today. And the next part of the plea paperwork talks about read-in offenses, but today there is no read-in offense, so that doesn't apply. The next part of the plea agreement talks about restitution for read-in charges, and again, there are no read-in charges. And also that if a charge is read in, that you can't be prosecuted for that in the future. So none of that really applies today, because the two charges that are being dismissed today are not being dismissed and read in, they're being dismissed outright. And then the last thing under understandings, it says that I understand that if the judge accepts my plea, the judge will find me guilty of the crime to which I am pleading based upon the facts in the criminal complaint and or the preliminary examination and or as stated in court. So do you understand that at the end of the hearing today, if I accept your guilty plea, I will find you guilty and we'll talk about a factual basis? Do you understand that, sir?
Yes, Your Honor.
All right. And then the next part of the plea paperwork is labeled voluntary plea, and it states that I have decided to enter this plea of my own free will. I have not been threatened or forced to enter this plea, and no promises have been made to me other than those contained in the plea agreement. Do you understand that, sir?
Yes, Your Honor.
And Mr. Brooks, has anybody threatened you in order to get you to accept this plea offer?
No, Your Honor.
Has anybody promised you anything other than the plea agreement that we talked about?
No, Your Honor.
All right. And the plea agreement, it says on here that the plea agreement is prison to the court, dismiss counts 1 and count 2. So, Mr. Brooks, that's all the information that's contained on the plea questionnaire and waiver of rights. Do you have any additional questions about anything that's on that plea questionnaire?
No, Your Honor.
So, Mr. Brooks, if I accept your plea today and we go to sentencing, do you understand that the way this will work is I will hear what the state has to say with regard to sentencing. I'll hear from your lawyers. And finally, Mr. Brooks, if you want to talk to me, I'll hear from you. But even if every single person recommends that I do the same thing, I don't have to follow anyone's recommendation. I can do what I think is the right thing to do, even if that means imposing the maximum sentence consecutive to any other sentence. Do you understand that, sir?
Yes, I do, Your Honor.
Prior to filing the plea paperwork, did you have an opportunity to discuss this plea with Mr. Rakestraw?
Yes, I did, Your Honor.
And are you making your decision to enter your guilty plea freely and voluntarily after having talked to Mr. Rakestraw and or Mr. Hampton about what your different choices or options were?
Yes, Your Honor.
During the time period that this case has been pending, have you had a chance to talk to Mr. Rakestraw and or Mr. Hampton or both about all the facts, about everything that happened on that day in July of 2020?
Yes, Your Honor.
So during your discussions with your lawyers, have you talked about possible defenses that you might have to this charge of felon in possession of a firearm?
Not in full, but it has been discussed.
Do you need more time to talk to them about the possible defenses you might have to the charge of felon in possession of a firearm?
I would maybe have just one question to them, but I don't think it would be anything that would alter what direction. Maybe just a little more clarity.
Okay, I'm going to ask Mr. Hampton or Mr. Rakestraw to step back into my jury room. They will log into my Zoom hearing. I'll open up a breakout room so the two of you can talk, okay? Or the three of you, I should say. I apologize.
Thank you, Your Honor.
You're welcome. And we'll just go off the record while we do that. I haven't seen Ms. Rockendorf.
She is out sick. I just got an email from her, so I'll cover her.
Okay.
plea.
All right. Because I did think I saw Mr. Yackman and Mr. Allen, but all right, we'll just wait. All right, Mr. Hampton has entered. I'm going to open up a breakout room. What'll happen, Mr. Brooks, is as soon as I open that and assign you to it, you'll go in automatically because that's the way that Department of Corrections sets up their Zoom hearing. So I don't know how you, do you know why you came out of that breakout room?
I do not, Your Honor.
All right, let's try this. I'm gonna move you to a different breakout room. This.
We're good, Your Honor.
All right, we'll go back on the record. The record should reflect that I did open up a breakout room. Mr. Hampton and Mr. Rakestraw logged in on a device so that they could speak to Mr. Brooks. Mr. Brooks, were Mr. Hampton and Mr. Rakestraw able to answer the question that you had?
Yes, Your Honor.
All right. So have you had an opportunity to talk to them about both the possible defenses you might have to this charge, as well as talk to them about what happened on July 24th of 2020, so that they would know if there was an explanation for your possession of the firearm that would explain it in a way that would make it not a crime?
Yes, Your Honor.
And they were able to answer all your questions about that. Is that correct?
Yes, Your Honor.
Are you satisfied with Mr. Rakestraw and Mr. Hampton and the help that they have provided to you?
Yes, Your Honor.
Are you at all confused about anything that we are doing here this morning?
No, Your Honor.
And do you understand by entering your guilty plea that you are giving up your right to pursue those defenses, as well as any other explanations, which would be called mitigating circumstances? Do you understand that, sir?
Yes, Your Honor.
And do you have any questions that you want to ask me or your lawyer about what your rights are, the plea procedures we've gone through, any of the questions I have already asked you, or anything else that's happening here this morning?
No, Your Honor. I have no questions.
Brooks, are you pleading guilty to the charge of felon in possession of a firearm as charged in count 3, because you are in fact guilty of that offense?
Yes, I am, Your Honor.
Defense counsels, have you gone over the plea questionnaire and waiver of rights forms with Mr. Brooks?
Yes, Your Honor.
Have you gone over the elements of the offense with him?
Yes, Your Honor.
Do you believe he understands those?
Yes, Your Honor.
Did you go over the maximum penalties?
Yes, Your Honor.
Do you believe he understands those?
Yes, Your Honor.
Have you gone over all possible defenses as well as mitigating circumstances?
We have, Your Honor.
And do you believe he understands those?
Yes, Your Honor.
Do you believe that Mr. Brooks understands all the rights that he is giving up by entering his guilty plea this morning?
Yes, Your Honor.
And do you believe that decision is being made freely, voluntarily, and intelligently?
Yes, Your Honor.
Does the state consent to the jury waiver?
Yes, Judge.
Mr. Brooks, I am going to accept your decision to enter your guilty plea. I am going to find that that decision has been made freely, voluntarily, and intelligently. Mr. Brooks, that's just a little bit of a fancier way of saying, I do think you understand what you're doing. I think you understand what you are charged with. I think you understand the maximum penalties. I think you understand your rights. And understanding all of those things, you have made a voluntary decision to give up your rights and enter your guilty plea. I make that decision based upon the information that's in the plea questionnaire and waiver of rights form. That tells me that you're 40 years old and you have completed 12 years of schooling, or you have a GED or HSED. With that age and that amount of schooling, you would clearly be able to understand all of the information that is contained in the plea questionnaire and waiver of rights forms. So that is important. I also make my decision based upon the answers to my questions today. You have been very, very good today at making sure you were clear. If you didn't understand something, you didn't hesitate to let me know that. So your answers to my questions have been clear. They have been direct. Everything about the way you look and the way you've acted today makes me believe that you do understand what you are doing. I also will note that we have had multiple court hearings on this matter, and at every court hearing, the way you have acted and the way you have carried yourself makes me completely comfortable that you completely understand what you are doing. And so I am going to accept your decision. Let's talk about the factual basis. The criminal complaint talks about some things that happened on July 25th of 2020 in the 4000 block of North 19th Street in the city and county of Milwaukee. So it says that the police went to a residence at that location. You were located there. You were taken into custody. They located a Beretta 9mm handgun that was on an air mattress close to where you were seated. So that handgun would have been, if not, would have been in an area that over which you were exercising control. And so therefore you had possession of it. And prior to that date of July 25th of 2020, you had been convicted in Milwaukee County case 1999 CF 4470 of the felony offense of substantial battery. That conviction remained on your record and had not been reversed. So Mr. Brooks, do you agree that on that date at that location that you possessed and exercised control over that firearm, and that prior to that date you had been convicted of a felony offense?
Yes, Your Honor.
Mr. Brooks, I'm going to find that that's an adequate factual basis, and based upon your plea of guilty and that factual basis, I am going to find you guilty of the charge of possession of a firearm by a felon as charged in count 3. That's contrary to Wisconsin statute section 941.29, paren 1M, paren A, 939.50, paren 3, paren G. Because I've accepted your plea and found you guilty, you are once again a convicted felon. That means you cannot possess a firearm. That's a lifetime ban. You cannot vote until your civil rights are restored. Based upon the information provided to the court by the state today, I will dismiss outright counts 1 and count 2 based upon the fact that the state was not and has not been able to proceed on those charges. Is it my understanding that the parties want to go to sentencing?
We can.
Yes, Your Honor.
Okay.
Thank you, Judge. Judge, the court is very familiar with this case. We were in a position to try the first 2 charges early on, but I don't want to get into that. Obviously, I don't want to preclude us if, in fact, we are able to pursue these charges in the future. Mr. Brooks did take responsibility today for the felon in possession of a firearm. The court has just gone over the factual basis that particular count is pretty straightforward. They were investigating the underlying shooting. They found Mr. Brooks at the residence. They found the gun very close proximity to Mr. Brooks. Mr. Brooks does obviously have a criminal history. He's got a 2010 strangulation from Wood County. He's got a 1999 battery from Milwaukee, a 1999 substantial battery from Milwaukee, a possession of controlled substance cocaine from 2000, a possession of controlled substance THC from 2002, a resisting or obstructing from 2012, 2012 possession of THC and bail jumping. There's another open matter currently in Milwaukee County, and then the court is familiar with Mr. Brooks's convictions in 2022 in Waukesha County. Judge, based on the totality of the circumstances, the state feels that a prison sentence is appropriate and leaves that to the discretion of the court.
Thank you very much.
Yes, Your Honor, for my client, Daryl Brooks, I'm making a recommendation to the court of 218 days in the House of Correction, which would be a time served disposition. Your Honor, Mr. Brooks is 40 years old, lifelong resident of Milwaukee. He has obtained his GED. He is the father of 5 children. As the state said, Your Honor, you're very familiar with the going-ons about this case in particular. Your Honor, the issue when it came to trial about this were about the first 2 counts, which were dismissed. Mr. Brooks was cooperative with officers in regards to count 3. He admitted to having a firearm to the police. If it was just about the felon in possession, this probably would have been taken care of a long time ago. Obviously, we deny any assertions that Mr. Brooks committed a shooting or shot at anyone or anything of that nature. So this was, and so he's here, he's accepted responsibility for the firearm, which he always was willing to do, Your Honor, and had made statements to police in regards to that firearm as well. Your Honor, we know Mr. Brooks is in prison for an extended amount of time. This was his first firearm case, at least to my knowledge. He's never had any other cases with the firearm. The firearm he stated to me he took from his 17-year-old son, but again, never shot that firearm at anyone, admitted to having it. I do not believe any extra prison time is necessary and is kind of moot at this point, given the sentence that he already has. So I believe a time served disposition, seeing as this is he's pleading to only the possession of a firearm, and it's his first time being charged with possession of a firearm. I do believe a time served disposition would be appropriate, Your Honor. And that's why, Your Honor, I am making a recommendation of 218 days in the House of Correction, which would be a time served disposition. I'm asking for no fine. I'd ask that you waive any costs due to indigency and the fact that Mr. Brooks is going to be incarcerated essentially for all of the foreseeable future. And Your Honor, he has 218 days of credit. Thank you.
Thank you. Mr. Brooks, is there anything you wanted to tell me today?
Yes, I do, Your Honor. First, I want to say it's been a long road to get to this point. It seems like I've been coming before you now forever for this matter. I just want to take responsibility for the mistake I made that day. As my attorney said, it wasn't a malicious mistake. It wasn't, I didn't possess a weapon for any malicious intent. That was not my goal in that matter. It was a stupid mistake. Definitely something that I knew better than to be doing. And, I'm just ready to move forward now. Obviously, Your Honor, you're familiar with the current situation that I'm in. I'm just ready to just move forward. I'm ready to tie up my loose ends, so to speak. Ironically, since this situation has happened, it's ironically served to make me and my children's bond a lot stronger. I guess for them seeing what the mistake that I made had caused me to have to deal with, it's actually made them not even want to partake in anything firearm based or anything criminally based themselves, just by seeing the strain that it's caused in my life. And that's something that I'm proud of, because I don't want my mistakes to rub off on them in any way. My son is now 20 years old now. He's going into the military himself. He's basically trying to get out of Milwaukee because he recognizes that it's very dangerous, and it's a lot going on in Milwaukee right now. He wants to better himself, and a lot of that was seeing from my mistakes and everything that I'm dealing with. So it's been rough. It's been stressful. It's caused a lot of grief. 3 years worth And I'm finally ready to put this behind me and do the best that I can going forward in the future, Your Honor. That's all I want to say. I thank you for giving me the opportunity to speak. I've tried my best to carry myself before you and before your court with respect to you and to the court. I've tried my best to keep my composure and do what's asked of me, and I'm ready to put this behind me and go forward.
Thank you very much, Mr. Brooks. So, when a court makes a decision on sentencing, there are three factors the court needs to look at. One would be the seriousness of the offense, two would be your character, and three would be the needs for protection of the public. And in looking at this offense, felons in possession of firearms is a serious offense. We talked about this a little bit during the discussion, the plea colloquy, but there used to be a 4-year mandatory minimum for this offense. So it's clearly something the legislature recognizes as serious. The public is very concerned about felons having guns. So the offense in and of itself is serious. When I look at the circumstances in which you are convicted of this, I will note that the charges from the day before were dismissed outright, so I'm not going to consider that. The day that you were arrested with this gun, you were cooperative. So I think that in the scope of felon in possession cases, this case falls to the middle or lower end of seriousness. When I look at your character, that's obviously an incredibly difficult thing for me or any other court to comment on. What happened in Waukesha is that happened, and you've gone through that process, and that can't be ignored. I appreciate what you just said about the relationship that you have with your children, because it's obvious, but I'll say it, your goal has to be to and it's an uphill battle, but to not make that define you. And certainly with your family and those who love you, you have the ability to do that. And beyond that, neither you nor I control how the general public views you. But so I am happy to hear what you said about the relationship with your children and your attempts to show them and to guide them. You've accepted responsibility here. It's been a long time in coming to fruition, but I know that, to be frank, the case was in a resolution posture, to my recollection, going back to 2020 on this, and then those other events intervened, and we ended up where we ended up. And then I look at what are the needs for protection of the public. As I said before, the public is rightfully concerned about felons possessing firearms. But in this particular situation, I mean, we've danced around the elephant in the room. There's nothing that I am going to do that is going to materially impact your situation. To be frank, I mean, it's a matter of public record what sentences you are serving, based upon. To a certain extent, this is an academic exercise, but ultimately, you've pled guilty to a felony offense, there has to be some, and you've accepted responsibility, there has to be some consequence on the record for that. So balancing those things, what I believe is appropriate is this. I am going to sentence you to a term of 4 years in the Wisconsin State Prison System, broken down as 2 years of initial confinement, followed by 2 years of extended supervision. I'm entering that sentence because, as I stated, in the scheme of felon in possession cases, I do believe this falls into the moderate or lower end, but prison, I think, is usually appropriate for felon in possession cases. So I am going to impose that sentence. I will make that sentence concurrent to the sentence in 21 CF 1848, which is your Waukesha County case. Again, given the length of that sentence, it just doesn't seem to make any sense to try and it'd be meaningless to run this consecutive. And so I'm going to run it concurrent. I don't know how that affects the pretrial calculation in terms of credit. I know Mr. Rakestraw indicated you had 218 days of independent credit. I'll certainly give you those 218 days. As conditions of extended supervision I guess let me first of all talk about court costs. I'm going to assess against you the mandatory DNA surcharge. I'll waive all other non-mandatory court costs. The DNA surcharge is to be paid from your prison account at amount determined reasonable by the department. Anything that is unpaid while you're in would be a condition of extended supervision. Anything that was unpaid on extended supervision would be converted to a civil judgment. I have not studied what if any conditions of extended supervision there were in case 21 CF 1848, but given the fact that that just drives everything here, I'm not going to add any additional conditions. I'll just indicate that if you're released on extended supervision, you should cooperate with any programming that is deemed appropriate by your supervising agent. As a convicted felon, you cannot possess a firearm. That is a lifetime ban, and you cannot vote until your civil rights are restored. Good luck to you, Mr. Brooks. Thank you for resolving your case. Mr. Rakestraw and Hampton, will you advise Mr. Brooks of his post-conviction rights?
Will do, Your Honor.
All right, thank you very much.
Thank you, Judge.
Good luck to you, sir.
Thank you, Your Honor.
Okay, I expected different behavior. That was completely out of character with the Darrell Brooks that we all know from Waukesha, and maybe for some of our people who aren't familiar with that. Let's see if we can find some of his highlights from let's see. Got to be careful of what ones I choose because it's all the same footage, but if you do it from Fox, they'll copyright claim. Okay, here we go. Let's get it queued up. Okay, let's.
Lawyers and represent himself.
Do you wish to represent yourself in this case?
Yes, I do.
Before, I'm sorry, go ahead.
I would like to represent myself pro per.
What does that mean to you, sir? Explain to me that request.
Again, because I've already said it on record, to represent myself as a sovereign citizen.
I'm not going to make a determination, sir, whether you're a sovereign citizen or not. It's not relevant to my determination how you characterize who you are. So if you are allowed to represent yourself in this case, sir, you will not have attorneys assisting you. If I let them withdraw, they're gone from this case. Do you understand that?
I think I will probably be better served representing myself.
And Judge Darrow did allow Brooks to represent himself. Now, he may look back on that decision and say that probably wasn't the best choice. But what was fascinating is that Brooks identifies as a sovereign citizen. This is someone who doesn't really believe that they are under the jurisdiction of the government, that they're exempt from U.S. laws, which is seemingly why he would make repeated statements about his legal name or statements that would undermine the authority of the court and the trial.
Sir, did you hear me tell you about the penalties for these offenses just now?
I don't understand the nature and cause of the charges.
I'm not asking you that, sir. Did you hear me advise you of the penalties for hit and run resulting in death?
I don't understand.
Mr. Brooks, any questions for this witness?
Yes, I do. For the record, I don't consent to that name. Are we going to address subject matter jurisdiction?
The written decision that I previously entered is what I will stand on. I'm not going to address it any further.
Is that verified proof? Can we address subject matter jurisdiction? It still has to be proven for the record?
I decline to do so.
Ah, yes, the infamous subject matter jurisdiction argument that he made throughout the trial, even till the very end. And it's an issue that really has no basis in law because this court does, in fact, have the jurisdiction to handle this criminal case. But as the trial progressed, Brooks became even more argumentative and would constantly interrupt the judge to the point that he would get kicked out of court and placed in a neighboring courtroom with audio and visual tools so he could see and hear everything. But it was intense and bizarre nonetheless.
Before, I need to make a record that at 8:42 a.m., this court ordered Mr. Brooks be removed from the courtroom due to repeated interruptions and disruption with the court. You can see that he is seated with his back to the court or to the camera. He took his shirt off as well. I'm also told that he is threatening to throw and break items.
Yeah. And that's just the beginning of it. So we're going to get more into Brooks's behavior in a minute, but let's get into the meat of the case, what this case is really about. We want to get into the actual crimes here. So several witnesses to this parade attack actually testified in graphic detail about what they saw and about what they heard.
So then you said you heard something?
Oh, yeah, I heard and saw the impact.
Tell us about
If you
that,
ever
please.
heard a car hit another car or an abutment or a deer, if anybody's ever hit a deer with their car, you've heard it. I watched the body fly up onto the hood and her head snapped back and the body remained on the hood as it passed the side of my vehicle to where I thought I could have just reached out and grabbed her.
So this happened that close to you?
Yes.
You saw all this with your own two eyes?
Yes.
Did the car continue past you?
Yes.
Where did it go?
The car veered kind of in front of me. I saw brake lights and saw what was Jane fall off the hood. He proceeded to and she was basically on the right side of his vehicle, and he proceeded to run her over with the right front tire, then the right rear tire. And at that point, I was just focused on the body on the ground, but I remember hearing the roar of the engine again.
Did you see the red SUV strike any people in the Catholic community group?
Several,
Can you estimate how many?
at least 15.
Okay. And did, I'm sorry to ask it this way, but did you see anybody like actually fly or roll or tumble?
Yeah, so originally I heard sounds like thuds, and then it was in the air, like bowling pins.
Okay.
And not only is this kind of incredible to have a murder case, to actually have eyewitnesses to a crime, let alone these many eyewitnesses, but they also were able to ID Brooks as the driver of the car.
I saw directly through the driver's window.
What did you see?
I saw a man focused on the group ahead of him.
Is that Daryl Brooks that you saw?
Yes.
Do you see the driver of the red SUV in the courtroom here today, Officer Schneider?
Objection, hearsay.
Overruled, she may answer.
I'd ask Mr. Brooks be directed to remove his mask so that Officer Schneider can identify him, please.
Objection, I never heard an answer to the question.
It has not been answered. Mr. Brooks, please remove your mask. Thank you.
Officer Schneider, is the driver of the red SUV that you've just described for this jury present in this courtroom today?
Objection, hearsay.
Can you please point him out by where he's seated and what he's wearing?
He is seated over here at the table wearing a gray suit.
That's the man you saw driving the red SUV as it sped past you?
Yes, it is.
And as strong as that was, it's not even the only evidence the prosecution laid out. They also showed the defendant's police interrogation tape. You see, after Brooks drove his car into the parade, police were alerted to a man going door to door to try to get help from people seemingly trying to evade law enforcement. Well, he eventually was arrested and he was brought in for an interrogation. And in this interview, the investigators don't initially ask him about the parade. Instead, they make it seem like it's just about a domestic violence incident that he was involved in. You see, prosecutors would say that Brooks actually got into a fight and attacked his ex-girlfriend, Erica Patterson, before driving the car into the parade. And maybe he ended up doing what he did out of anger. You know, the motive has never really been clear here about why he did, but maybe it had to do with the fight with Erica Patterson. Well, just listen to Brooks's reaction when he realizes what's really going on.
We been cool, man, the whole time. If I did something, wrong,
that's why they were here. But do you see them here today? They're not here today.
Yeah, but y'all lied to me, man. You made it seem like they just come for no reason.
Well, here's the thing, Darrell.
And I'm like, what
Hey,
if it's
listen to
today?
me for a minute.
I
I can give you a clean slate here.
I apologize.
Because you have lied to us as well. Because you came out here in the red Ford Escape. Okay, that is what you came out here in. You had the key, right? So what I want to do is try to give us all a chance to reset. You understand what I'm saying? Start over. Because you're not giving us an accurate story.
What if it wasn't me driving? What if it wasn't you? What if it was my mom's truck? Mm-hmm. But I wasn't driving. Mm-hmm. What if it was you? What if it wasn't me? Mm-hmm. Who else would it be? That's what I'm asking. Not me.
That's not you.
That's not me.
That's not you.
No, I don't.
Darrell.
That's
Darrell.
That's you.
That's you, Darrell.
Why you say it like that, man?
Oh, right. He wasn't driving, but what happens if he knows who was? Right. Yeah, that's what makes sense here. Suspicious behavior? I would say so. He seems more concerned with the tactics that police use than really giving them good explanations. Now, Brooks, like I said, represented himself throughout the course of this trial. And to give you a sense, this is where he went when he cross-examined the state's witnesses. You can kind of see his defense.
Do you know why the vehicle was beeping its horn?
I imagine that the driver was angry and wanted to get through the crowd.
And how did you come to that determination?
I've been driving a long time, and a lot of times people get angry, they're late, they beat their horn at you in a way that is because they're upset and they're trying to get past you.
Do you know that for sure?
You asked me my opinion.
Yes, I did ask your opinion. Now I'm asking you, do you know for sure if the driver of the vehicle you observed was in fact angry?
I assume that he was.
You thought because of that sound that there had to be some mechanical problems going on with the engine.
I thought that there could be.
But it was your first initial thought, correct?
Correct.
And you were able to hear that sound and come to a conclusion that possibly there were mechanical issues all in a few seconds.
A lot runs through your mind at that point in time. Yes.
And you can see Brooks seemed to suggest a few things here. One, maybe it wasn't the intention of the driver to hit anyone. Maybe he was honking to get people out of the way. And two, maybe there was a mechanical issue with the SUV and the driver lost control. The only problem with that is that a state inspector testified to the complete opposite. He reviewed the steering wheel, the tires, the brakes, the gas pedals, and said that there was no mechanical issue that the driver would have lost control. And also, even putting that aside, the honking, if you honk, but you didn't stop, what does it matter? That's the point. He drove the car. He didn't stop. He kept mowing people down. Doesn't matter if he hung. But what made this trial so different and so out there was the defendant's behavior as he represented himself, because he would constantly interrupt the judge and bring up these legal theories that had no basis in fact and law. And the ups and the downs with his behavior was so startling. And at one point, let's begin. After he had a few of these outbursts, he actually apologized.
I would like to issue the court an apology from me in regards to my actions last week during the trial. I just want the court to understand it's very emotional right now, not only for just the whole situation of the trial, the families here that have to go through, everything that's going to be involved with the trial, but also my family as well and myself is very, very emotional. But not to excuse my actions, I should carry myself with better respect than that. I wasn't raised that way.
The I wasn't raised that way is really something else. But we all knew this didn't last long.
I'm a grown man with grown kids. Ain't nobody gonna talk to me like that. Nobody. I don't have a problem with doing what you asked me to do, not tell me. Just like when I asked you about subject matter jurisdiction that you have yet to prove on the record. But somehow I'm being intentionally disruptive. Come on, man. Stop. Just stop it.
Jury's coming out.
All rise for the jury.
Not gonna work.
Yeah, and it only got worse.
I don't care what you believe fully.
All right.
It's not a game. I don't take this as a game. That's what nobody. You don't gotta explain nothing to me.
Do you want?
That's what you don't understand. You think that this is a whole game to me. This is not a game to me, Your Honor.
Now, in fact, there was one point when he got so angry. You see, Brooks had called as a witness his ex-girlfriend, Erica Patterson. Now, she had previously testified for the state, and it's alleged that Brooks got into a fight with her and attacked her right before he drove the car into the parade. And Brooks, when he had her on the stand, what he wanted to do was introduce these photographs to arguably show that she wasn't a credible witness and also a bad mother. So when prosecutor Zach Witchow talked about what would happen if these photos were allowed into evidence, he said that he'd have no choice but to reveal something very negative about Brooks's past. And again, this was all outside the presence of the jury. And thank goodness, because look how Brooks blew up.
Second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with
the child in question. He doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada. And for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
Furthermore,
I object to that.
I'm not
because that's a lie.
Let him
Because at the end
finish.
of the day,
Let
if
him
we- if
finish,
we're gonna open the door
Mr.
on that. No,
Brooks.
since he want to make a record and not be accurate, so let's be accurate all on the record. Since you think you know so much,
Once
so
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can open
loud,
the door on how old she told me
disrespectful,
she was when we met.
interrupting.
We can ask
He's-
that question
he is
too. Then
over the
Did you
top
ask that?
animated
Did you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state
No,
finish.
no, I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just gonna take an early lunch, 1 hour, we'll be back. And unless he brings that letter and he can show it is inadmissible, he will not be questioned. And under 90611, I will declare the cross-examination closed. Thank you, we're in recess, 1 hour.
Get your facts straight. So let's open the door on all of it then, so we can get all of it on the record. Since you think you know so much. Did you know she said she was 18 when I met her? Did you know that?
And if you thought that was bad, the worst of the worst is when at one point the judge had to stop court proceedings because she was actually scared of Brooks.
So as long as the jury's out, we should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had
of
to be
the-
that had to be said. So it's the defendant.
That's not how it was said. I
That was how I
completely
said. You want to run the
disagree.
record back?
Mr. Brooks.
So I'm the only one. I got one. I
Mr.
got one
Brooks.
ear that work, and I heard that.
This
Come on,
is
man.
to benefit you so
No,
that
it's
you
not.
understand
Ain't none of
your
this to benefit me,
witness
so let's be
has a
clear about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice. This is the
So she had to
alleged
elevate her
record of
voice
Abel
just for that.
Lescott.
Stop talking.
Come on, man. Like I don't know who y'all be thinking y'all fooling. I set the value in return for value this document.
One more interruption and you're going to be removed to the next courtroom.
That's what you want to do anyway.
It's not what I want to do. Do not interrupt Attorney Opper.
So can
Your
you
Honor,
tell,
I
can you
believe he
explain-
has 7 prior criminal convictions via OWI 2nd from 1997, and OWI 3rd from 1997, and OWI 4th from 2003, criminal trespass to dwelling from 2006.
All right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared.
Now, despite all of these outbursts, the judge moved forward with the trial. She gave Brooks a lot of leeway. She continued to allow him to represent himself. She didn't kick him out of the court all the time, although it happened a lot. And I've said it before because a lot of people have asked, why did she do that? Well, a common theory is that she did this because she wanted to preserve the record for appeal. That if he gets convicted, an appellate court can't say that the judge acted unfairly to Brooks, that she gave him every warning, every admonishment, and the only person that torpedoed Brooks's case was Brooks himself. And that also included when the judge said to Brooks that he forfeited his right to call any more witnesses or take the stand himself because he refused to answer her questions. Now, he claimed he couldn't hear what was being said when he was in the adjacent courtroom, but an IT specialist and a bailiff testified that the volume was loud and clear. Either way, after this, after Brooks was told that he forfeited his right to present a defense, he was particularly upset.
My final question to you, do you have any requests as it relates to the jury instructions?
I just told you, am I muted? Am I muted?
No.
I just told you, I don't know how many times, I can't hear everything you say.
Then you should put the headphones on.
Don't you understand? What about that don't you understand? If you see headphones, you can see everything. You can see boxes, but then you see headphones.
Have you asked for headphones to be provided, sir?
I should have to ask him. I asked for my boxes to be moved.
I believe they took them away previously because you were so agitated. They were perhaps afraid you might break
Yeah,
them.
I'm still agitated. I ain't gonna stop being agitated. That ain't gonna stop.
sit up here and do everything you're doing and think God don't see what you're doing? You ought to be ashamed of yourself.
Talking to a judge, it's just shocking. Well, with him forfeiting his right to present a further defense, the trial headed for the end a lot sooner than we anticipated. I mean, it would have been really something and very interesting to have Darrell Brooks testify, take the stand, and particularly be cross-examined. But alas, it was not meant to be, and given his noncompliance, we move forward with the closing arguments. This is the last attempt in closing arguments for both sides to persuade this jury to vote a certain way. Closing arguments are not evidence. They're basically a summation of the case. First up, prosecutor Sue Opper.
He had plenty of opportunity to just stop anywhere along the way. One of the officers testified to it. I think it was Officer Schneider. This was an accident, and he mistakenly wandered onto the parade route after passing all this, and he mistakenly wandered onto the parade route. At any point, all he had to do was stop. They could have paused the parade. They could have moved the barricades and escorted him out. He didn't. It was intentional. He went on for 4 blocks. 4 blocks. It was intentional. He reached speeds of approximately 30 miles an hour. That's intentional. He plowed through 68 different people. 68. How can you hit 1 and keep going? How can you hit 2 and keep going? How can you hit 3 and keep going? Didn't faze him a bit. He kept going until he got to the end, and there was no more bodies to hit. It's intentional.
Again, she's really focusing on the intent here. She's focusing on the 6 counts of first-degree intentional homicide in particular, and that if you had any question about what he was doing, just look at his actions. But Brooks had a response. A defendant or a defense attorney can present a closing argument. Obviously, he's representing himself, and he presented the closing argument, and he went into areas that he really wasn't allowed to go, though.
You should be informed that you have the power to nullify any law that you don't agree with.
Objection. Move to strike the statement.
Sustained.
Objection.
I will strike from the record the last statement made by the defendant. The jury will disregard it.
Which is clearly what I've been saying. I believe that not only is it fair, but it's essential that you be privy to all knowledge, not knowledge that certain people feel that you should hear and shouldn't hear, disguised under the color of law. But the fact of the matter is, the vehicle in question a model of 2010 Ford Escape, actually 2008, 2009, and 2010 of that model was in fact recalled.
Objection. Misstatement of the facts. Facts not in evidence.
Was in
Improper
fact
argument, Your Honor.
Sustained.
Was in fact recalled. Was in fact a class action lawsuit against Ford
Objection.
for those
Facts not in
model
evidence,
for
Your
those
Honor.
model vehicles.
Sustained. The jury will disregard.
Information that you should have been privy to, that you weren't allowed to be privy to. Why? I don't know. That information, malfunctioning throttle bodies.
Mr. Brooks, move on.
Okay, so first, a defendant can't argue jury nullification. Jury nullification is when a jury decides a case not based on the facts and the law, but some other reason, political, emotional. They're not allowed to do that. And that's what Brooks is basically advocating for here. He's basically saying, even if the prosecution proved beyond a reasonable doubt that he's guilty, you, jury, have the power to say otherwise. You can say not guilty. And this is despite objections from the prosecution and an order from the court telling him not to do it. He kept saying it. And by the way, the idea of a malfunctioning car, as we discussed, not only was there no evidence to suggest that wasn't even the case, but you can't argue something that wasn't presented in evidence. There was no evidence presented at trial about a recall or a class action. So all of this was irrelevant. Well, the jury was ultimately handed the case, and after about 3 hours and 15 minutes, the jury came back with their verdict.
We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information, dated this 26th day of October 2022, signed by the foreperson. Hey, you are to be removed right now. You will not do that.
There you have it. They found him guilty across the board of all 76 charges, including 6 counts of first-degree intentional homicide, which carry a mandatory sentence of life in prison. And at the time of this recording, the sentencing date hasn't been set yet, but we believe that the victims' family members, they're all going to have an opportunity to make statements. And also Mr. Brooks and anyone on his side can make statements as well. And we're definitely going to follow it and hopefully report on it here on Sidebar. But I do want to leave you with this before we go. As much as this trial and the attention to this trial focused on the actions and behavior of the defendant, we can't forget what this case is really about, and that is the victims, and particularly the 6 people who were killed in this nonsensical tragedy. And that's all we have for you, everybody. Thanks so much for joining us here on Sidebar. Please subscribe on Apple Podcasts, Spotify, YouTube, or
Once again, you're doing this tactic.
Because
You try to
it's not a tactic, it's
what we're
facts.
talking
It's
about
facts.
to some other reason.
It's facts. Because
some
I
other
find
thing.
it hard to believe that
I'm gonna
all
let
of
the
a sudden
state.
nobody hears what I say.
I'm gonna let the
Oh,
state
man,
make a
stop.
record of why they
Stop.
believe it's objectionable, because I haven't let them do that.
we go over the top 5 outbursts of defendant Darrell Brooks in the Waukesha Parade tragedy trial. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. The trial of Darrell Brooks Jr. out of Waukesha, Wisconsin has really been something else. On one hand, we can't forget what this trial is about. You have a defendant who's been charged with over 70 crimes for allegedly driving his SUV into a group of holiday parade goers back on November 21st, 2021, ultimately resulting in the death of 6 people and injuries to dozens of others. And this is a very serious case and a very tragic case. But at the same time, we can't forget that this trial is incredibly unique and strange because the defendant has chosen at the very beginning of trial to represent himself. And it has been a roller coaster ride of fights between him and the judge, him getting kicked out of court. He took his shirt off at one point, and he brings up these legal theories that seemingly have no basis in fact or law that delay the whole proceedings. And this is partially due to the fact that we believe Brooks identifies as a sovereign citizen. This is someone who believes that they're not under the jurisdiction or authority of the government. So we thought, why not revisit the top 5 outbursts of Darrell Brooks during this trial? And I'd like to start with a particularly bad one. You see, at one point, Brooks called as a witness his ex-girlfriend, Erica Patterson, as he was presenting his case. Now, she had previously testified for the state, and it's alleged that Darrell Brooks, got into a fight with Erica Patterson and attacked her right before he drove his car into the parade. So when she was on the stand, he wanted to show that she wasn't a good mother and that she's not a credible witness and that she wasn't telling the truth, particularly about the last time that she had had contact with him. And that's when, while she's on the stand, he pulls out these photographs, and the state objected because they hadn't been shown these before. And outside the presence of the jury, prosecutor Zach Witchow talked about what would happen if these photos were allowed in, and he revealed something very bad about Brooks' past. And as you'll see, Brooks was not too happy about it.
3, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom. I think that is what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada. And for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
Furthermore,
I'll object to that.
I'm not
because
sure.
that's a lie.
Let
Because
him
at the end
finish.
of the day,
Let
if
him
we
finish,
gonna open the door
Mr.
on that, no,
Brooks.
since he want to make a record and not be accurate, so let's be accurate all on the record. Since you think you know so much,
Once
so
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can open the door
loud,
on how old she told me she
disrespectful,
was when we met.
interrupting.
We can ask
He's-
that question
he is
too. Then
over the
Did you
top,
ask that?
animated
Did you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state
No,
finish.
no, I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be back. And unless he brings that letter, and he
Don't
can
sit
show
there and try
it
to
is
think you know what's
inadmissible.
going
She will
on.
not be questioned. And under 90611, I will
You gonna
declare
talk
the
about where my kids live.
cross-examination
You don't know where,
closed.
You don't know where, what
Thank
happened
you.
at
We're
the
in
time
recess,
all this
1
happened,
hour.
bruh. Get your facts straight. So let's open the door on all of it then, so we can get all of it on the record. Since you think you know so much. Did you know she said she was 18 when I met her? Did you know that?
Now, luckily, as I said, this was outside the presence of the jury, and that is a very good thing for Brooks that they didn't see that. Clearly, he's trying to relitigate his past relationship that he had with Patterson and whether or not he should have been convicted of that sex crime. And of course, this is just another example of him being removed from the courtroom. You know, look, Brooks has repeatedly made statements that this process is totally unfair, that he's not being heard, and he adamantly denies that he's trying to deliberately obstruct the proceedings. He feels that he's just trying to get his word out and his rights protected. In fact, in another major outburst and show of disrespect to the court and the procedure, he yells at the judge about what this trial is about.
I don't care what you believe fully.
All right.
It's not a game. I don't take this as a game. That's what nobody, you don't got to explain nothing to me.
Do you want?
That's what you don't understand. You think
you
that
want
this
the
is a whole
opportunity
game
to
to me.
question?
This is not a game to me, Your Honor. Nothing about this is a joke.
I never
That's
said
what
it
y'all
was a
don't
joke.
understand.
But there's
And it's
some things in the
unfair.
ship
It's
that's going on.
unfair and it's disrespectful to me that you think I would come in here purposely and treat this like a joke or a game.
I never said it was a
What
joke.
type of statement is that?
Mr.
Your life is not on the line. Mine is. And you think that I think this is funny?
I don't think it's funny whatsoever.
So,
And I
so I
understand.
think, Your Honor, with all due respect, I think you
So
should show
we're
some
gonna take
respect.
a 5-minute break, and when we come back, the jury's coming out, and you need to call your next witness. Thank you. We are in recess.
No, you're not rushing me to judgment. I don't care what you're talking about.
Unbelievable that he's saying this to a judge. A judge. I sometimes have to remind myself who he's speaking to. And, you know, there is so much discussion about Judge Darrow here showing this restraint. You know, why didn't she kick him out of the courtroom sooner? Why didn't she kick him out multiple times? And I think there's one theory that at least I believe is that she is giving him so much leeway, so much opportunity to reel himself in. And she's deliberately making sure that she doesn't prematurely silence him or kick him out of the courtroom too quickly. Because the theory is that if he's convicted, an appellate court then can't say that she was unfair to him, right? The only person who buried his case was Darrell Brooks himself, that she wasn't being unfair or violating his rights, that she gave him every opportunity to correct his behavior. And some believe that this is a sign that he shouldn't be allowed to represent himself anymore, but that's his right. And while there could be opportunities for judges to step in and say that the defendant is not competent and an attorney should be assigned at this point, this judge is not at that point. She believes that he is doing all of this deliberately to delay these proceedings, and he knew what he was getting himself into when he decided to represent himself. And I think at the very least, it seems that Mr. Brooks has issues with authority, because if you listen to what he said to Judge Darrow multiple times, this one in particular was really egregious.
I'm a grown man with grown kids. Ain't nobody gonna talk to me like that. Nobody. I don't have a problem with doing what you ask me to do, not tell me. Just like when I asked you about subject matter jurisdiction that you have yet to prove on the record. But somehow I'm being intentionally disruptive. Come on, man. Stop. Just stop it.
Jury's coming out.
All rise for the jury.
Not gonna work.
And that is not the only time that he barked at the judge and told her what her job should be.
If you don't make a record,
So
then
what?
I can't make a ruling.
It threw people off a loop. They weren't ready for it. They scared of it. That's what it is. Come on, man.
Mr. Brooks.
Come on, man. Stop.
When you
Stop.
you aren't
Stop
even
it.
letting
You're a
me
public
ask the
servant, Your Honor.
questions.
I respect your courtroom. I
You
respect you. You're a public servant, though. Your job is to be the referee. Is it or is it not? You stated so yourself on record that your job is being the umpire.
Your Honor, can I ask Ms. Patterson please be excused?
Yes, you can be excused. My apologies.
My apologies too, but it needs to be some truth. Especially when we're talking about stuff that didn't even happen, but they're allowed to get on the stand and say that it happened when they know it didn't happen.
So I'm going to make a record about what
This
he's
is
referring
ridiculous,
to
man.
in count 77.
Truth be told, I could do a 2-hour show on all of the disruptions and the hostile moments in court. But I have to tell you, after reviewing it, there is one moment in particular, one time when I was actually nervous for the safety of the people in the courtroom, and including the judge. And this came about when the prosecution started presenting an issue and how the prosecutor, Sue Opper, said the word defendant. Take a look.
There's an issue that we do need to pick up potential as to a witness by the name of Abel Lescano. He has prior criminal history.
Thank you.
So as long as the jury's out, we should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had
of
to be
the-
said. So it's the defendant.
That's not how it was said.
That was how I said.
completely
You want to run the
disagree.
record back?
Mr. Brooks.
So I'm the only one. I got one. I
Mr.
got one
Brooks.
ear that work, and I heard that.
This
Come on,
is
man.
to
Come on,
benefit
man.
you so
No,
that
it's
you
not.
understand
Ain't none of this
your
to benefit me,
witness
so let's be
has a
clear about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice. This is the
So she had to
alleged
elevate her
record of
voice
Abel
just for
Lescano.
that.
Stop talking.
Come on, man. Like, I don't know who y'all be thinking y'all fooling. I accept the value in return for value this document.
One more interruption and you're going to be removed to the next courtroom.
That's what you want to do anyway.
It's not what I want to do. Do not interrupt Attorney Opper.
So can
Your
you
Honor,
tell,
I
can you
believe he
explain-
has 7 prior criminal convictions via OWI 2nd from 1997, and OWI 3rd from 1997, and OWI 4th from 2003, criminal trespass to dwelling from 2006.
All right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared.
So, as we record this, we are coming to the end of the Darrell Brooks trial. After the judge deemed Brooks was non-responsive to her question, she ruled that Brooks forfeited his right to call more witnesses or even testify himself. He has been repeatedly kicked out of the courtroom. In fact, he's spending the majority of his time outside of the courtroom in that adjacent courtroom. And after the judge reads the jury instructions, we go to the closing arguments, and then this case is handed off to the jury. They're going to have 152 verdict forms. That is a lot of paperwork, a lot for them to decide. And I'll tell you one thing, all said and done, this is certainly a case that we won't forget. And thanks everybody for joining us here on Sidebar. Please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. Speak to you next time.
Oh, God.
License, registration, proof of insurance, please. You don't have a driver's license. I don't believe this is a laughing matter. Yeah. This is not funny. Okay. Thank you for your license and fine. Have a good day.
Say bye-bye.
Bye-bye.
On the run again.
Isn't related in any to this.
How do I get my granddaughter's things back from him then? How?
Well, you can file what's called a, just a minute. You can file what's called a claim and delivery action, which is not small claims. In small claims, all I can order is money damages. So you could hire a lawyer and file a claim and delivery, and if the judge orders it, the sheriff goes and gets the stuff back. It's hard to do pro per without a lawyer like small claims is. But this is a discrete amount. He added $840, which didn't apply to anything, just like your counterclaim didn't. But let's say your granddaughter's things are worth $3,000. You can sue him for $3,000, but it doesn't get the things back. If you want to get the things back, you have to file what's called a claim and delivery action. So it's tough, particularly when there's not a lot of money involved. And the things may be important, maybe baby pictures or keepsakes.
Anything that belonged to her mother. I mean,
yes. So that's a separate matter. I'm going to make this August 15th and then August 1st and the 15th of each month. Mr. Lafferty, he contends you've got some items that you won't return. What's the story regarding that?
Well, you want the long story or the short story, Your Honor?
Well, wouldn't it be easier to just give it back?
Well, it's not a matter of giving it back. The problem is there is no way to contact Grace, my daughter. Rex, I guess, figured out how to block my number via Grace or Mindy. I don't know. So the communication is the biggest issue. I was talking to Grace's boyfriend, but then he wanted to throw out a childish idle threat. So at that point, I shut him down. We had packed all of Grace's clothing up and what personal items of her mom's that are in my basement. And unfortunately, we're doing some remodeling and we had a major flood. So everything that we packed about 3 weeks ago, I've been dry cleaning and redoing. So, and that's basically clothing and shoes and that kind of stuff, nothing real sentimental. So it's, that on top of just the lack of communication, it's not that Grace can't have her stuff. It's just that the only time I ever heard from Rex is when he showed up on my doorstep and basically told me he was going to the probate court because my daughter chose to not follow rules at home because she was smoking pot, had pot in my house.
I don't really want to get into all that. This is
okay. That's why I asked.
All right. Yes, you're right. I stuck my foot in it. I don't have a good answer for you, Mr. Bartlett. You can sue him. It seems like it'd be a lot easier to give it back, but this isn't about things or it isn't about money. It's about hard feelings between parties, and the court is getting dragged into stuff that ought to just be resolved without the assistance of the court, but that's what small claims is for. All right, I'm ordering the $1,000 at $100 per month, starting August 15th. The bailiff will take you out, Mr. Bartlett. You can get a copy of this and then you're free to go. All right, Mr. Lafferty. If he does not pay it, you can do what's called a discovery subpoena. Might make things better if you could make arrangements to return the property. Maybe that'd speed things up.
And
All
you know,
right,
my daughter's property had nothing to do with this because this story's changed.
I understand it does not, which is why I didn't want to get into it.
Yeah.
All right, Mr. Taylor and Mr. Thompson, I'll be with you in just a minute. Mr. and Mrs. Large, why don't you come up? Return to the matter of Garth and Linda Large versus Pablo Pena and Amber Fox. We were here by Zoom on June 26th. We took quite a bit of testimony and I reviewed a large packet of photographs which supported just a minute. I thought I was done with this guy. Which supported Mr. and Mrs. Large's claim for at least $6,500 worth of damage. The photographs showed the property was in deplorable condition. Mr. Lafferty, you came back. Did we forget something?
No, I didn't know what happened, so I didn't know if I should log back in and just.
Yeah, no, I excuse you. You're good to go.
Oh, okay.
All right. They had filed a counterclaim for alleged property that it was kind of hard to discern. It was all scribbled on here.
I don't know, he may be brought in today, so let's go and I'd like to be able to get started this afternoon, then we'll take on those questions. If he's gonna testify today, right before he testifies. Thank you. You have your next witness ready?
Yes, Your Honor, it's Josh Nunez.
Nunez, that's right, okay. All right, let's bring the jury in, please. You're in over here, so just have a seat over here and we'll get you. Thank you. Please have a seat. Could you please stand? Please raise your right hand.
You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, sir. You can have a seat. Pull up your chair to the mic, and you can start when ready, Mr. Allen.
Thank you. Good afternoon. I'm going to ask you to raise that mic, speak loudly into the mic so the court reporter can hear you, please.
Yes, sir.
Okay. Can you please state your name for the record?
Joshua Nunez.
Okay, Joshua. How old are you?
I'm 36 years old. I'm sorry.
Okay. How are you employed?
With this city of Laredo.
How?
I'm a patrol supervisor with the Laredo Police Department.
Okay, and if you could just speak into the mic, how long have you been with the Laredo Police Department?
I'm on my 12th year right now.
Okay. Are you a licensed peace officer?
Yes, sir.
Okay. What are your current duties and responsibilities?
I supervise a group of officers, issue assignments, make sure they have proper equipment, report to any major incidents that happen around the city in my area.
What other assignments or positions have you held with the Laredo Police Department?
I was also assigned to the Special Investigations Unit when I was an investigator.
Okay, so you've been a patrol officer?
Yes, sir.
And you've been an investigator?
Yes, sir.
And now you're a supervisor?
Yes, sir.
Now, I want to ask you about the name of Grizelda Hernandez and Dominic Hernandez. Do you know them?
Yes, sir.
And please tell the ladies and gentlemen of the jury how you know them.
Grizelda is my cousin. We call her Gray.
You call her what?
Gray.
Okay. And Dominic is her baby.
Yes, sir.
Okay. What was the age gap between you and Grizelda?
We were about 4 or 5 years apart.
Okay. How are you her cousin?
Through my mom's side, my mom and her mom are sisters.
Okay. So Grizelda's mom and your mom are sisters.
Yes, sir.
Your mom's name is what?
Mary.
And your aunt, his name
is also Mary, but I would call her Tia Yoli.
Tia Yoli.
Yes.
Okay. All right. So you guys are first cousins.
Yes, sir.
Okay. Tell us about your childhood with her.
We would, any usual, regular family, get together on holidays, birthdays, the barbecues, babysitting, sometimes just randomly go over to each other's houses and be there with the family and all that.
What kind of childhood was it?
It was good. We're all kids, playing all the time and stuff. So who doesn't have fun as a kid?
And where were some of the different places you guys would play?
My house, her house, at my other uncle's house. We used to have a ranch also. They would go to the ranch as well.
So you have good memories?
Yes, sir.
Okay. I want to, what about when you all became adults and, let me ask you this. Eventually you guys grew up, right?
Yes, sir.
You started your family?
Yes, sir.
Okay. And you guys went into your careers?
Yes, sir.
Did you all stay close or kind of
No,
grow apart?
we fell apart over the years as we got older.
Yeah. Got busy.
Yes, sir.
With your own life. I want to direct your attention though to April the 9th of 2018.
Okay.
Okay. Do you remember that day?
Yes, sir.
Okay. Tell us, were you working that day?
Yes.
And where were you working or what were you doing?
At that time, I was an investigator. I was doing a follow up on a case in South Laredo.
Okay. At what time was that?
It was in the afternoon, but maybe like 9, 10, 11, somewhere around there.
Okay. So it's around 11 in the morning, more or
Yes,
less?
yes.
Okay. And what, if anything, do you remember from that day?
I had my radio off and I usually have it on. So when I turned it on, I started hearing certain transmissions that were coming through.
Like what?
They were calling out that they had found some bodies by the riverbanks. I heard a specific one that started to ring a bell, was mostly about a white Mercedes. And then somebody had came out with the registered owner's name and I recognized the name.
What was the name you heard on the radio?
I heard Angelica Hernandez.
And who is Angelica Hernandez?
She's my cousin.
Your first cousin?
Yes.
And what is she to Grizelda?
She's Grizelda's sister.
So once you hear that over the radio, what, if anything, do you do or how do you feel?
Once I heard that, I started to go back to the station because I started to remember my mother had told me that my cousin had purchased a white Mercedes. So when I get to the station, I start looking at the call through the computer I have there. Once I heard again over the radio that they had made contact with, I call her Angie, but Angelica. I went to go tell my immediate supervisor at the time that, hey, this is more than likely my family that's involved.
Who did you tell that to?
Sergeant Cordelia Perez.
Cordy Perez.
Yes.
So you tell her, I think my family's involved in this.
Yes.
So what, if anything, do you do next?
I let her know that I had heard that they had made contact with my cousin Angie. So, I mean, I started to tell her, I mean, the body that they found, and I know they had mentioned a baby also. I told her it's more than likely going to be my other cousin Gray that's there.
Okay, so what do you do next?
Sergeant Perez was asking me like, hey, are you sure it's family? Are you sure it's family? I'm like, yes. I mean, I kind of remember the address that they went to. So then that's when she decided that we should go there to the scene to see if how we can help out and all that.
How did you get to the scene?
We went on Mines Road, and then we ended up at the park, and that's where their Lieutenant Ramirez was there with some other investigators.
And who drove, you or your?
Sergeant Perez drove.
Sergeant Perez drove you. And what's going through your head at this time? As you're being driven over there.
I mean, I wanted to contact family to start seeing, hey, is it them, not them? I just didn't want to start spreading information around the city or through anybody and have people panic, or my family panic and all that, and show up anywhere.
So you decide not to contact anybody in your family?
Yes, sir.
Until you, and then tell us when you arrive at the crime scene. What do you see? Walk us through.
When I get to the park or the actual crime scene?
Well, to the park, and what do you give me an order, a chronological order of what you're seeing as you get there with Cordy Perez.
So when we're at the park, the white Mercedes is there. I do see some investigators talking with a Border Patrol agent. They're passing me information that, of course, there's a body over there by the brush along with a baby that they found. And we're trying to put the pieces together. I get on my Facebook and I get on my aunt's page to see if I could find pictures so I can start showing the lieutenants and the sergeant investigators, say this might be possibly the victim and all that. I do call my mother at the time, not alarming her of what's going on, but I started kind of just asking her questions. Hey, you know what, is great dating anybody right now? Do you know she has a boyfriend? Do you know when's the last time you talked with her? She starts panicking over the phone, but I just didn't want to say anything anymore.
Okay, and then what happens next? What do you do?
From there, I tell the lieutenant, hey, this might be her. I show him the picture. I know I did see them detain a Border Patrol agent. I didn't know any of his information or anything. At that point, they did need somebody to ID the bodies, and I volunteered to do it.
Okay, so tell us how that happens.
I was hearing all the transmissions about what they had found, and some investigators and officers there were kind of describing the scene and all that stuff. I know for any case they need a direct family member to go ID the bodies. I kind of put it together that I knew it was going to be bad the way they were describing it to me, so there was no way I was going to let my aunt or my cousins go and see what was there.
So you volunteered to be the one?
Yes, sir.
And then tell us what happened, or tell the jury.
So my direct supervisor at the time asked me if I was sure I wanted to go. So I said yes. I mean, any law enforcement deputy, state trooper out on the field, I mean, scenes that they respond to, it's kind of like a gut feeling in a sense that we get when we know something's gonna be bad, just the way they're describing it to us. So that's when I told them, yes, I'm gonna go and I'll help tidy the body.
Okay, so what happens next?
So from there, we walk from the park over to the scene. We passed some soccer fields. There were officers already lined up throughout that path, just letting us know, hey, don't walk through here, don't walk on this side. So we make our way through the soccer field, and then we go through the brush, and we end up on a dirt trail, and that's when I see 2 Border Patrol units parked back to back.
Okay, and after you spot the 2 Border Patrol units, tell the jury what you see and what you feel.
So from there, I met with some officers and Investigator Garcia, who was already on scene. When I looked down the dirt path, that's when from a distance I saw the first body lying there across the dirt road. So I got closer because they wanted to see if I could ID from that distance. So I walked through the brush on the side where they had taped off kind of like a safe area to walk through without messing the crime scene. I couldn't ID the first body because she was face down and I couldn't see her face. So then from there, that's when I hadn't seen where the second body was, but they pointed that the baby was a little bit further down by a tree.
Did you go see the dead baby?
Yes.
What did you do after that?
From there, I just let them know I couldn't ID Gray because she was face down. Well, the female at the time. And I couldn't identify the baby either because I hadn't seen the baby in person.
You'd only seen the baby in pictures?
Yes, sir.
Okay. So eventually, are you able to identify Grizz?
Yes. I believe one of the medical examiner arrived there and they turned her face over, and that's how I was able to ID her.
When they turned her face over or turned her over?
Turned her over, yes.
That's when you made the positive ID?
Yes, sir.
Okay. How did you feel at that time?
It's the way I can describe it is as a law enforcement officer, it's hard when you see a victim deceased. It's heartbreaking when you see a baby, but then it's a different type of feeling when you see that it's a family member that's in front of you.
And you've seen victims before, right?
Yes, sir.
In your line of work as a detective?
Yes, sir.
But this was different?
Yes, sir.
What other emotions did you have at that time?
The next thing was, of course, to notify my family.
So what do?
From there, I told Sergeant Perez, like, I'll go to the house and I'll help out on telling them. And at the time, Investigator Benavides, the sergeant right now, had gone with us also. So we get to the house, and I saw them, and I think they already knew what we were gonna say. So, and of course, we told them about Gray first. What was, I think, even worse at the moment was I remember my cousin Angie saying that she wanted to go pick up Dominic. They had no idea yet.
Oh, she was thinking that Dominic was still alive?
Yes.
Did you break it to them, or
Yes, we ended up telling her that she couldn't because he was also gone.
So is there anything that stood out to you about this crime scene as far as evidence and what you saw?
There was a lot of blood, and I'll never get the image of when they turned her over so I can ID her face.
It's been 5 years. How has this affected you?
The simplest way I could explain it is, I've never really opened up or told anybody about it or reached out for help, but I see the scene basically every day for the past 5 years. Again, hard to believe. I like to do physical training, so I would run on a trail by my house. For the longest time, there's a part where it's like brush and there's mesquite trees, an outdoors type of thing. I couldn't believe it the first time, but I had seen like they were there by the tree, and then I tried to ignore it and thought it was just mind tricks or something, but I kept on seeing it until eventually I just stopped running through there for a very long time. The only thing that helped was that they cleared that area because they did construction of new houses by there.
This is over by your house?
Yes, sir.
And have you been able to get or seek any help for this trauma?
I never did. I just, how bad it was, I didn't want to reach out for help. And then for my family to ask, well, why are you going to counseling? Because for whatever reason, I didn't want to let them know how bad it was that day.
Okay. No further questions.
I'm really sorry for your loss, officer. We have no questions.
Hi, Jeff. Next witness. The state calls Detective Raimundo Garcia. You may, I think yes, I think you got sworn in the other day with, again. Okay, I'm going to ask you, good afternoon, sir. I'm going to ask you again for your name for the record.
Yes, my name is Raimundo Dani Garcia.
Okay, is the mic on there in front of you?
Yes, Raimundo Dani Garcia.
Okay. And again, you're the lead investigator in the double homicide case against Ronald Anthony Burgos-Aviles, correct?
Correct.
Okay. Now, we had already learned that as part of this investigation, you were able to have the phone of Ronald Anthony Burgos-Aviles dumped and analyzed.
Correct.
If you can tell the ladies, some of the jury, what sort of information were you able to extract from his phone in the form of communications?
Yes, we were able to extract phone calls, text messages, images, videos, and so forth.
Were you able to, as part of your investigation, extract information surrounding the text message activity of Ronald Anthony Burgos-Aviles at, or rephrase, before the murders, around the time of the murders, and after the murders?
Yes.
Okay. And in what specifically is in text messages, were you able to track his text messaging around that time?
Yes.
Tell the ladies and gentlemen of the jury, who, if anyone, was he texting in that period of time from the morning up until the time of his arrest?
He was texting a female that was in his contacts.
Were you able to identify her? Were you able to identify her identity without saying her name?
Yes, we were.
Okay. And did she also have a username?
Yes, she did.
And what letter did it start with?
It started with the letter Z.
Okay. And for purposes of this trial, we're going to call her letter Z, correct?
Correct.
Okay. Anyone else he would have been having communications with surrounding before, during, or after the murders in this case?
Yes, he also had communications with his wife.
Okay. And what is her name?
Amy Burgos.
Amy Burgos. Okay. Anybody from his employment?
Yes, supervisors.
Do you remember the name of the supervisor he was texting, or the last name?
I want to say Ali.
Ali.
Last name Ali.
Okay. And you found text messages to Ali?
Yes.
Okay. As part of these text messages at or near the time of the murders, were there also images being sent back and forth?
Yeah, yes, they were.
Okay. And these images that were being sent back and forth, who were they being sent by?
The images were sent by Burgos and also the contact Z.
Look, Steph, I got an instant online offer on my car from CarMax.
Well, I got an instanter offer on my car.
Crunchy cookie M&Ms.
Right. Then, so, Captain Corey, terribly sorry, missed out on this. Meant to say it, forgot to say it, didn't say it. Gonna say it now. Saying it, I'll say it. I hear tell of something they speak about in the ages of now called the YouTube channel, which I don't understand, but why not? And I understand that you're quite the YouTube channel man, or you shall be, and all that YouTubeness to be. So what I'm saying is, I shall be glad to follow your YouTube channel, and I shall tell all my friends to follow your YouTube channel, and that I think will make for a wonderful entertainment expertise, momentary lapse of togetherness all together in one space, but far apart. But then at the same time, very close, curious, enduring, and strange. However, I shall be there watching every moment and watching moments with you, momenting and tubing you, YouTubing. I wish you the best of luck. I'm your number one fan, Captain Corey. All respect and love, mate.
So I'm gonna approach you with, yeah, because I think we're young off. So I'm gonna show you State's Exhibit 556.
Yes,
Are you familiar with this document?
I am.
And without telling me the contents, what is it?
They're the text message that Burgos had during the April 9th, 2018.
And this is
It's-
moments before, during, and after the murders.
That's correct.
From his phone.
From his phone.
I think they've already seen 556. But...
Same objections are stated at the bench, Your Honor.
Objections overruled. Now, within these text messages that have just been admitted, you said that there was some photographs
Correct.
sent back and forth
Correct.
between
Burgos and Z.
Burgos and Z. I'm gonna show you what's the mark that states exhibit 559,
Yes.
560, and 561.
Yes. Seen it before.
And where were these photos obtained?
And Burgos' phone, cell phone.
You have the same objections? You incorporate Mr. Shoneman's objections from earlier?
Yes, Your Honor.
All right, you're offering,
I'm offering
and you incorporate your argument as well,
559, 560, 561. These are the
Yeah.
photos from those text messages.
taking into account all arguments of counsel in the case presented, of course. Your objections are overruled. They are admitted.
Okay. So I'm gonna start here. 4/9/2018. That's UTC time. It'll be -5. It would be -5, correct?
Correct.
So what time would that be?
I'm sorry, I don't see where you're pointing to.
That'd be -5, 12 -5.
That would be 7:56
In the morning, correct?
in the morning AM.
And what does it say?
I'm at work. Love you.
What does it say?
Amy.
And who is Amy?
Amy is Burgos' wife.
What does it say here?
Love you, babe.
All right. What does it say here?
That says, hey.
And that's from what? From who?
That is from Burgos to Z. Hey. What's up? To Z, who's that white boy Burton? Why he working with BP?
So this is Amy.
Yes. I'm in lane, babe. Oh no, did the soups talk shit because of the trade? That's from Alejandro Ali.
Who's Alejandro Ali?
He's a supervisor of Burgos.
And what does he say?
He says call Vela at extension.
Here?
And that's a message from Z. replying to the message earlier, he's enforcement. He got picked to do that detail. Why? This is from Burgos. Why not? Why not you? You could have been working. Whatever. That's to the supervisor Ali at 10-4.
Who put that 10-4 is from Burgos to Ali?
Yes. Not yet. I haven't seen any soups. I went straight to Lane. That's from Amy. And from Z, you got that detail too?
And just for the record, Burgos first reached out to Z that morning, correct?
Correct.
And what do we have here?
That is a message with an image sent at 8:40
8:40
a.m.
a.m. Now this is close to the time of the murders, correct?
That's correct.
And what is that image?
That image is of a female butt with underwear.
With underwear.
Yes.
You had said that that Burgos was sexting around the time of.
Objection, Your Honor. I don't think the witness ever said the same.
Well, let me ask you, based on the activity that you found here between Burgos and Z, that you recovered from Burgos is sent to Burgos from who?
That image was sent from Z to Burgos.
At what time was this image received?
I believe it was 8:40 a.m. approximate.
What was the last text or the last Snapchat from Grizelda to Burgos?
It was at 9:44 a.m.
That's an hour and 4 minutes before this.
That's correct.
What's the next communication?
That's a message to Z from Burgos. I'm not on the detail. I supervised them, but I could have worked with you.
Yeah, but what did this say here?
Oh, I'm sorry. Yes, booty gains. ¿Qué piensas? What do you think?
There's a couple of words mixed in here, Your Honor. Can we get that translated?
Yes, I'm gonna.
They're just sprinkled in. Is he
Right,
ready?
as long as you say the Spanish, then she'll say it in English.
Okay, so 8:40 was the first text from Z. And then what time is this at now?
That's at 8:42 a.m.
So 2 minutes later, Burgos responds to Z.
¿Por qué me mandas ese fake sabiendo que lo quiero? Ugh.
Why did you send me that fake knowing that I want it?
At 8:42, correct?
That's correct.
This is from who to who?
That is from Z to Burgos.
What does it say?
So if I was there, you would have gone more often to supervise? And he responds, duh, I'd pair you up with me in the unit. And she responds, lies, you wouldn't do that. Burgos, whatever. And then from Z, I'm getting hot again, gordis.
Fatty.
This text is from who?
The one that I just said,
No, this one I'm showing.
the one with the image is from Burgos.
So what time is this at?
That is 8:49 a.m.
At 8:49 a.m. Now we're inside the hour of 9:44, right?
Correct.
Grizelda's last text, correct?
Correct.
So we're now inside an hour. So takes you to the 560. What is this?
It's an image of a crotch. It's also appears to be the green uniform of Border Patrol, without the utility belt, just the underbelt.
Just the underbelt. And what time is this pick, this crotch pick sent?
Believe it was 8:40, approximately 8:40.
Well, the first one was 8:40. This one would have been.
Yeah, 8:49. 8:49 a.m.
Is there any text accompanying that pick?
Yes.
What is,
It reads, thanks to your stupid pick, now I'm horny again.
that's from Burgos.
That's from Burgos. That's from Burgos also. From Z. Que.
What?
And to Z. Nada, me mojé y se me paró.
Nothing. I got wet and it got up.
And this is from Burgos to the Z
Correct. At 8:51 a.m.
continue here
At 8:56 a.m.
okay, 8:56 a.m. This is from who to who?
From Z to Burgos. Saca papi.
Your Honor, this is the interpreter. Can that be repeated again? I didn't hear it.
Saca papi.
Get it out, Papa, Daddy.
The next one
At 1:56 a.m. She responds un tease. And yes, Burgos replies, sácamelo tú.
You take it out.
So now this is at 9:07 a.m. I'm going to the gym from Z.
What time is it here now?
9:08 a.m.
9:08 a.m. And this is from who to who?
This is to Z from Burgos.
And what does Burgos say?
Warm up on my dick. Hazte unos squats ahí.
Do some squats there.
Response?
Ahí, gordo.
Right there, Fatty.
And then he replies at 9:21 a.m. question mark. Okay, no me des.
Okay, don't give it to me.
9:23 a.m. from Z to Burgos. Why you call and hang up? 9:24 a.m. To Z from Burgos. Because I realize you're just gonna deny me. So pa que me ilusiono con el fakey?
So why do I get my hopes up with the fake?
So 9:32 a.m. from Z to Burgos. Please, you confuse me with some other bitch. And he responds, question mark. So 9:39 a.m. from Z. Okay. Burgos responds at 9:39 a.m. Ya cállate, Tis. Me dejaste con las ganotas otra vez.
Stop the tease. You left me with the wanting again.
So that's 9:39 a.m.
How close is that to 9:44?
It's about 5 minutes. 5 minutes to 9:44.
Grizelda's getting near the dirt trail at this time.
Correct. Next is from yes.
Page 287. State's Exhibit 556.
Okay, so that message is from Z at 12. Hermoso.
Let me back up over here. Do you see this over here?
Let her just get that translation.
Oh, okay.
Beautiful.
I'm gonna back up to 451.
That should be 11:51 a.m.
What does it say?
It's a message from Rene Soup Alejandro, and it asks pictures and GPS when you get the chance.
This is already after the calls, the report for the
Yes,
dead body is already.
correct.
You're already on scene.
I'm already on scene. Correct.
Burgos is on scene.
Correct. I'm sorry. Okay, it's 12 p.m. and it's a message from Burgos to Soup Alejandro. I didn't take picture and they are not letting me. At 12:01 to Z, Dine. I think she meant to say Dime. 5:01. I'm sorry. 12 p.m. to Z, Dime.
Tell me.
To 12:05 p.m. from Z. I miss you.
12:05 p.m. By this time, has Dominic's body been found?
Yes.
The crime scene is being processed.
No, correct. That's a correction. Dominic's body has not been found. It's an approximate time.
Okay. What's next at 12:05?
12:05 is from the supervisor, Rene Alejandro. Is the net cleared?
At 12:05.
To the supervisor, Alejandro. Clear it for me. From Rene Sup Alejandro, 10:04. And from Rene Sup Alejandro at 12:08 p.m. Second dead body found, question mark. And at 12:09 p.m. to Supervisor Alejandro from Burgos, yes.
Burgos is answering the supervisor that the second dead body, the body of the baby, has been found.
That's correct.
What happens next?
At 12:09 p.m. to Z, I miss you. I miss you too.
Who sends that message?
Burgos.
After that message?
From Rene Sup Alejandro at 10:04, responding to his previous message. It's 12:12 p.m. and this message is from Z to Burgos. I mean it. (12:12 p.m.) Rene Sup Alejandro, send me coordinates for the second body, for the second subject. (12:13 p.m.) This is a message from Burgos to Sup Alejandro. Scene is secured. They don't let us contaminate. 12:13 to Rene Sup Alejandro. A correction from Rene Sup Alejandro. Cool. And at 12:14, Burgos to Z. Yo a ti.
Me to you.
12:15 p.m. To Z. Question mark. And 12:18 to 12:18 p.m. To, from Z. Question mark. So message at 12:22 p.m. from Rene Sup Alejandro. Were they wearing clothes that look like IA? Question mark. I believe it's illegal alien. From Rene Sup Alejandro, was their clothes wet? Question mark. And Burgos responds to Sup Alejandro, hard to tell, stand by. PD is saying she might be USC, United States citizen. This is a message from Rene Sup Alejandro, 10:04. This is at 12:45 p.m. From Uribe supervisor. Ronald, who from BP was on scene and how many were on scene prior to PD declaring it a crime? Is there a case number we can get from PD? And Burgos responds, Burgos, Lara, Dennison, Herndon, Smith, and Victor Barbarena from Intel. Only me, Lara, and Smith arrived on scene first. This is from Uribe Soup at 12:49 p.m. Have all agents departed the declared crime scene? And at 12:51 p.m., Soup Padilla sends a message. Pics, question mark. Can't see.
Mr. Oh,
From Soup Padilla at 12:51. I mean, for me.
By this time, he's already communicated to Supervisor Padilla, Supervisor Ali, and Supervisor Uribe.
Correct. 12:52 p.m. to Uribe Soup. Not yet. PD taking statements. Then he gives our case number, PD case number 8810. And this is from Rene Soup Alejandro at 12:59 p.m. at 10:18. Not from the Border Patrol. And 12:59 p.m. to Soup Alejandro, PD case number 8810. At 1 o'clock p.m. from Rene Soup Alejandro, 10-4. At 1 from Uribe Soup, 10-4, thanks. And then at 1:12 p.m. To Amy, there's a nasty situation. Just so you know, I'm busy. I'll let you know once I get home. Amy responds at 1:35 p.m. Okay. At 1:36 p.m. from Z. ¿Cómo se mira mi popis?
How does I'm sorry, did you say pompis?
Yes, I believe he meant to put pompis.
How does my butt look?
Publishing 561. 561 is the image in the text message.
Correct.
And this is at what time?
That was at 1. That was at 1:37 p.m.
Where are you at the point of your investigation at 1:37?
1:37. I would just say that is getting close to the time that he's detained.
Does your report indicate when Burgos was taken into or when he was detained?
It should. Yes.
At what time is he detained?
I mean, without looking at this, I could tell you it was at approximately 1:57.
At 1:57. Okay. 26th,
That's correct.
19 minutes before he's detained.
Correct.
What about this?
That's 1:38 p.m. to Z from Burgos. Dame.
Give me.
That's 1:52 p.m. from Uribe Soup. Please advise agents of peer support should they need it. This includes yourself. That's a message to Rene Soup Alejandro, LPD Detective Ray Garcia, office number, cell number, taking over scene.
That's you.
That's me.
You're taking over the scene. This is at what time?
That should be at 5 p.m.
Go ahead.
That's
Well, it's all right, but Mr. Alani,
Yes.
approach, please.
yes.
Now, at any point in time during this investigation, did you all interview Mr. Burgos's wife?
Yes, we did.
Yes, we did.
Okay, and what day was that interview done?
On that same day on April 9th, 2018.
Okay. Was it in the afternoon or in the evening?
It would have been in the evening.
Okay. Did you get to observe Miss Amy Burgos's interview?
Yes, I reviewed the interview.
I guess that's the,
Yeah.
when she was interviewed, what was her emotional state? Was she advised of the murders?
Yes.
Objection, Your Honor. This is hearsay, there's confrontation problems. The witness has already said, as I understand it, he did not personally even do the murder.
I'm asking him if he observed the interview.
Observed it. We're not, approach us to anticipate where you're going with.
Sure.
That way we can.
Was Amy Burgos brought in?
Yes.
What was her demeanor and her reaction to what happened?
Without them.
Yeah, without telling me what she said, I just want to know what was her demeanor and her reaction.
I would say she was in a state of shock and disbelief. She even cried during the interview.
Okay. Did you all, as part of your investigation, conduct a search of Mr. Burgos's home?
Yes, we did.
And did you all take photographs inside his house?
Yes.
May I approach you on? I'm going to show you what I've marked as State's Exhibit 562, 563, 564, 565, 566, and 567.
Yes, I've seen these before.
And do these pictures accurately depict what's contained within them?
Yes, they do.
And this location is Ronald Anthony Burgos-Aviles
Residents.
When did you all go there?
We went on that day, April 9th, 2018.
Maintaining our prior objection.
With regard to the interview,
Yes, Your Honor.
not sure which were the prior objections on these.
I believe we had a hearing pre-trial.
Okay. I'll show you the pictures. I'm still trying to, remember what your prior objections was. I don't remember those photos in pre-trial.
Your Honor, may we approach?
Yes, please.
So, thank you, Your Honor. So you all go to Mr. Burgos' house, correct?
Correct.
Before I publish these pictures, explain to ladies and gentlemen, what you all see around the house.
It's a messy house, and around the walls there are several damages, just from experience caused by a fist.
Exhibit 563.
Five what?
563.
All right.
Exhibit 564. Exhibit 565. Exhibit 567. What is this over here, officer?
It's damage to the door.
As part of your investigation, were you able to determine if Mr., and this has been covered, but that was he in possession of child support documents?
Yes.
Okay. Do you know how many mailbox keys were found on Mr. Burgos?
Yes. Just one mailbox key that we found in his wallet.
Do you know who that key belonged to? If you know. If you know.
Yeah, it was a mailbox key that we later released to the wife. So I would say it would belong to the family.
Now, as part of your investigation, did you obtain any videos from Mr. Burgos' phone the night before going into past midnight before the murders?
Can you say the question?
You dumped Burgos' phone.
Yes.
Correct?
Yes.
His activities the morning of or the night before the murders.
Yes.
Were there any videos of himself in his phone?
Yes.
If there
Well,
were-
not on the phone. On his Snapchat.
Okay, on his Snapchat. Okay. I'm gonna show you if I can approach you. And the Snapchat was also downloaded, correct?
That's correct.
I'm gonna show you what's been marked exhibit 562. And I'm gonna show you what's been marked as state's exhibit 557. Ask you if you recognize that USB.
Is that number correct? I think you got 562 already. You might want to.
Yeah, those are my initials. Yes,
One
I
second,
recognize.
sir. One
I'm
second.
sorry. I'm sorry.
I'm sorry, this was pre-labeled, so I'll remark it with a new number. That would be now 568. Thank you. Thank you, and I apologize for that. Okay. I'll show you now what's been marked as 568. You recognize that?
Yes.
What is it?
It's the data for that video that's in that USB.
And you were saying this USB, you recognize it?
Yes, I do.
And you viewed it?
I viewed it.
How do you know?
It has my initials on it.
We're gonna offer 557 and 568.
And 567, 560, the thumb drive?
Yes, it's a thumb drive, and 568 is
Just maybe briefly approach.
Oh, 568 is the one that goes in front of it. Yeah. Yes, sir.
So, also as part of the videos that you were able to recover, did you recover any interactions between Mr. Burgos and any of his children?
Yes.
Your Honor, can we approach this?
Well, let's see.
Because it's gonna
Yeah,
probably-
it is. Afternoon break while we iron this one out, and we'll be right back. Remember that we still haven't given you the case. So minor instructions. Thank you. Please have a seat.
We found the case.
All right, sir, go ahead.
So I want, put
Afternoon break while we iron this one out, and we'll be right back. Remember that we still haven't given you the case. So minor instructions.
Next, we're in the Broward County Bond Court in Fort Lauderdale, Florida.
Go ahead, ma'am.
Mr. Shanus, Abraham Arthur Shanus, and I have been legally divorced for 31 years, and I have the papers to prove it.
This is 80-year-old Dolores Shinus. She landed herself in jail for resisting arrest after violating a restraining order filed by her ex-husband.
We both resided at 20 Bend, and he paid for the apartment entirely. His assumption is because he paid for the apartment, he's entitled to do as he pleases.
I can't get in the middle of who owns the apartment.
I know, that's not the point. The point I'm telling you.
I need to keep you away from him, all right?
I haven't bothered him for 31 years. Why would I bother him now?
Rather than actually getting up in arms, Judge John Hurley decides to release Shinus on a personal recognizance bond, so long as she agrees to stay away from her ex-husband.
You are not allowed to call him, text him, email him. You are to stay 500 feet from him at all times. That's where he lives, where he works, anywhere in between. Ma'am, you're getting a second chance on this case. I don't particularly feel like keeping an 80-year-old woman in the jail who has no criminal record. But this is your second warning. Don't go around him again.
I swear to God and all that's holy on a stack of Bibles, I will never go near him, talk to him, call him, or
What was
even
the
look
first
at him.
thing you were going to swear on besides the Bibles? All that's holy. What?
I don't remember.
Oh.
What?
All that's holy.
What?
All that's holy. Yeah.
Oh, all that's holy. Yes, sir. I didn't recognize your twang.
The senior's sassy remark catches Judge Hurley off guard.
Ma'am, have you ever thought of doing a stand-up routine? Have you ever thought about that?
I did. If you pay me good money, sweetheart, I'll be there. I'm really short of funds.
Ma'am, I got to tell you something. You seem like you have a great wit about you.
I do, sir.
Yeah. So.
I mean, sweetheart, that's the only thing I have.
I've been called sweetheart in this courtroom.
Does that mean you're taking me for breakfast?
Let me ask you something, ma'am.
Yes, sir.
How have I done as a judge today? So far, how am I doing?
Not bad, but you could do better.
Can we get a drum roll with this?
With the case already wrapped up, the only thing the judge, the public defender, and all the other inmates are waiting for is one final punchline.
I got to tell you, you brightened my day, ma'am. All right?
That's what the last guy said, and then he sued me.
Thanks for being a fan of Court Cam.
And cats, they're not usually known for their love of swimming, but one feline in Northern Virginia is hitting the water instead of the gym in an effort to lose weight. Holly is a 13-year-old cat who dislikes the outdoors and other physical activities, but with encouragement from her owner and weekly visits to the Old Town Pet Resort. Holly has managed to lose 1 pound in 6 weeks. Stay with us, everybody. We've got a lot more to go.
if and when this goes to trial. Absolutely. I'm just trying to get a little more perspective here. Now, is it phentermine? I don't. Start with a story involving a 19-year-old. Okay, she seems younger than she actually is when she speaks. Maybe has had a little bit of a sheltered life. I don't know. She's 19, gives birth to a child in the hospital bathroom by herself. She's in a hospital. She goes in the bathroom, gives birth, then wraps the child in plastic, puts the child in the trash, covers it with more plastic. The child is dead. Now she's charged with murder. And we're all trying to figure out this case. Like, how does this happen? How she's in a hospital, for goodness sake. She's in the hospital. They didn't know that she was in labor. She didn't call out for a little bit of help. I don't understand it. No one understands it. Take a listen. Here's the charge nurse who was interviewed by police at the scene.
She had taken it and put it in the regular trash, and there's still trash all around the baby. She put it right in the trash can. Then she twisted it and wrapped it underneath him and then set the baby in the bottom. Then she put paper towels on top and then 2 wadded up trash cans or liners. They were clean on top of that. And then she placed a brand new clean liner in the trash can like it was ready to take trash. That's what I found.
So you said cold and blue already?
Cold and blue already. His temperature was like 95. No signs of life, no breathing, no respirations, no heartbeat, nothing, no movement whatsoever.
So her name's Alexi Treviso. Now, we spoke with her attorney and long conversation with him. And it seems they believe that the hospital is responsible here for what happened. It's not a murder case. It's the hospital who perhaps, according to the defense, they may go this way, caused the death of this child. So we got to take a look at the autopsy results and take a look. The cause of death here was asphyxia, suffocation, strangulation by entrapment. Manner of death, homicide. How the injury occurred. Child was tied in a plastic bag. Now, in this autopsy, they said, yeah, there was air in the lungs. The baby took breaths. So how is it not murder? Well, tonight we're going to take a look at the toxicology report. I'm going to put it up on the screen. I can't explain it to you, but caffeine, presumed positive, morphine, 19 nanograms per milliliter, and we believe the morphine was administered by the hospital. Then phentermine, 420 nanograms per milliliter. What does this mean? What does this mean? I need an expert. Let's bring in our guest to help analyze these results. Joining us in Barrington, Rhode Island, board-certified forensic pathologist, Dr. Priya Banerjee. Doctor, thank you so much for joining us tonight. I'm trying to understand the toxicology tonight. This is brand new for us. I spoke with the defense counsel. He was talking about the morphine, this 19 nanograms per milliliter. What does that tell you about what happened to this baby?
Yeah, so I mean, it's a complex picture. You know, we have to take sort of forest and trees. I mean, we're looking, the toxicology is part of the puzzle. Now, I think you're correct that the morphine was given in the setting of her back pain. That was her chief complaint. Now, that's still a therapeutic level. You know, what goes into the mom goes into the baby, right? So that's how we know that the baby even got it.
So is that, you say, a therapeutic level? Could that cause problems for the child? Because, again, the defense may very well argue that the morphine caused the child to die after taking 1 or 2 breaths, whatever their expert is going to say. Is
right. I mean, these are very complex cases, and I haven't even reviewed like the autopsy itself. With that caveat, though, could it have impacted a newborn's breathing? Potentially, but you have to remember that, you know, like after a C-section, I received other opioids, right, for pain, and that breast milk was still getting into the baby. So I don't think they would have given her anything to harm the baby. Now, could it have impeded breathing? Potentially, but you know, you can't ignore that the baby was very, very like carefully disposed of, right? I think her reaction and the disposal of the baby is the most horrifying part of this.
Oh, absolutely. Absolutely. And not calling out for help and not saying anything. That's a big part of this.
Baby, I think, you know, then she should have brought it out to the nurses, etc. But, you know, that's where we get into the nuances of the case. Did the baby cry? Did it not? I do want to put out there, though, that the baby got CPR, I think, if I'm not mistaken. That's a very critical element to clarify, because that can artificially inflate the lungs or get air in the stomach. So you don't want to overcall that, you know, and we know she's already at the hospital. They're going to try to resuscitate a baby, you know, not just assume it's dead. So I just want to put these little caveats out there. These are not straightforward cases at all.
No, and I expect a huge battle of the experts if and when this goes to trial. Absolutely. I'm just trying to get a little more perspective here. Now, is it phentermine? I don't.
Yep, it's phentermine.
Phentermine, 420 nanograms per milliliter. Is that a lot? Should someone who's pregnant be taking that? Can that impact the child as well?
I mean, anything the mom takes impacts the child. You have to remember that. Now, this is normally a diet drug. If you recall back in the day, fen, that sort of combination that's no longer used for other medical complications, that it was part of that combination. So, you know, why is she on a diet drug while she's pregnant? It's probably to conceal the pregnancy. You know, I bet her friends or family asked, you know, she's pretty petite from her pictures and even now, right? She's only 5 feet tall and she looks like a slim build. So I'm sure her stomach became prominent. Now, maybe she's saying I'm gaining weight and that's why the phentermine's in her system. This is available. I even checked before I logged on, like online, you can buy it without a prescription. So it's a traditional diet drug.
Yeah, and what's not clear in the case is whether or not she knew she was pregnant.
Right.
And, you know, she's 19. Does she think she's gaining weight? So she's taking diet pills. And then what impact does that have on the child? What impact does the morphine? A lot of questions in this one. Dr. Priya Banerjee, great to see you tonight. Thank you so much for making a house call.
Take care. Good night.
All right, let's bring our think tank. Friday night, joining us in Atlanta, Georgia, family law attorney, law professor at Emory University, Randy Kessler. Also with us tonight in Washington, D.C., you recognize him, the attorney who represented Johnny Depp in his defamation case, won that case, by the way, in case you didn't see the end of it. Everybody saw the end of it. And fellow of the American College of Trial Lawyers, Ben Chu, is with us. And in Cleveland, Ohio, retired judge, former criminal prosecutor for Cuyahoga County in Ohio, judicial fellow at the National Judicial College, Gail Byers. All right, great to see everyone on this Friday. Sorry, guys, I'm going ladies first, plus the judge goes first. Anyway, what are you thinking here, Judge? This case, to me, especially after speaking with Alexi's defense attorney, they're gonna say it's the hospital's fault. The hospital. You're in a hospital. They know that she's pregnant. She goes to the bathroom. She's in labor. They gave her morphine. They're going to say that the hospital killed this baby.
And, you know, Vinny, I think that that's wholly expected. There is, just as you indicated, going to be a battle of the experts. in this case, you're going to have the defense that essentially has the responsibility of convincing a single juror that they should at least not buy whatever the prosecutor's story is. Because remember, the prosecution has the burden of proof. They must prove beyond a reasonable doubt every essential element of the crimes charged. And I believe there are two, the murder and the tampering. And all the defense has to do, if anything, is to find one holdout. And they will no doubt rely on that argument, positioning or transitioning the responsibility to the hospital in an effort to achieve that, while the prosecution must convince every single juror that the defendant is in fact guilty. Now, what I will say is, just as the doctor said in the prior segment, there's something to be said for this marriage of, criminal act and criminal mind. And there's going to be, I think, some considerable attention paid to the level and effort that was or allegedly taken to conceal the body of the baby.
I know what they're going to say there. She's in a panic. She's 19. Her mother's in the room. She's like, oh my, all this is happening at once. How would you react, ladies and gentlemen, if you were 19 years old and you didn't know you were pregnant?
这实在是很无聊哎，这样也行。这实在是很无聊哎，这样也行。
Welcome to Popcorn Planet. My name is Andy Signor, and we have truly tragic news today. If you haven't heard online, we lost Captain Corey. He has set sail to a greater place, I'd like to think, and he made all our worlds better for the time he spent here in it. This is a tough one, guys. I know a lot of us expected and saw this coming at some point, but it never really hit you until it hits you. And this one hit me hard. I got to be honest. This one hit me hard. I got the news from Pixie herself, Corey's mom, and I was a bit of a mess yesterday. And my kid was there. Sawyer was there, thankfully, and he had been following Corey with me, and the two of us just hugged. No one should have to face what this family's faced. And this little boy was an angel. Not because of the Johnny Depp stuff that brought us all in, and I love Johnny for doing it, but getting to know him and his family, he is an angel. He was so positive, so amazing, and I'm not ever going to forget him, and I'm going to ensure that his legacy continues. I've made a tribute for him that I'm going to play for you, but I wanted to make sure I reacted because I know everybody keeps messaging me. And for those of you who aren't on social media, I want to make sure you did get the news that Corey has passed. He passed yesterday on Sunday around 7:30 p.m. In his mom's arms. She did post a video on Twitter. I'm not going to post that here. I retweeted it. You guys can go watch it. Just, it's rough. I have spoken to her. I know she's struggling. I know the family is respecting privacy right now and time, and that's what we're going to give them. And if they're ready to do anything beyond to help continue his legacy, we will be here to amplify it as loud as we can. For those of you who are unfamiliar with Corey's story, Corey was born with hypoplastic left heart syndrome, meaning that the left side of his heart was underdeveloped. Surgeons gave Corey a new heart in 2018, but the organ was rejected, and he underwent a second transplant in January of 2020. However, that was a very traumatic experience, very painful. His body did not accept the heart. He and his family and medical teams made the difficult decision to not face the ordeal a third time. As we all know, one of his last wishes was to speak to his idol, Captain Jack Sparrow, who responded in style. He also wanted to reach a YouTube milestone of 100,000 subscribers and get a plaque, which he did. And I have that moment, along with others, in a tribute that I edited this morning in honor of our dear Captain Corey.
It's my plane button! It's a really good camera. Oh my gosh. Yes, he got it! Did you see the camera? Thank you so much. I couldn't have done any of this without you. Thank you so much.
So, Captain Corey, I shall be there watching every moment and watching moments with you momenting and tubing you. Tubing you, YouTubing. I wish you the best of luck. I'm your number one fan, Captain Corey.
I think this proves one thing. If you believe in something and you keep pushing, eventually you'll get it.
Dude, you just helped us raise $65,000 for Make-A-Wish.
I'm sorry, what?
Yeah. 65,000.
Holy shit.
What do you want to say to the amazing community? You helped inspire this, dude.
Thank you all so much. You are all impacting other people's lives massively, and you don't know what you've done today. It could make millions of kids happy because of what you've done. You guys have brought millions of smiles to future kids. Thank you so much for having me on here and for supporting me. Thank you guys for helping to donate this much money and make future kids, all kids now, very, very happy. I love you guys all, and balls, because why not?
I remember the first and second time Corey was told, or I was told that Corey could have a new heart. And I knew that somebody would have to have passed away for Corey to be able to live. It is such a beautiful, selfless, incredible act if you can pass on something to somebody else to give them a chance at life. Now, I have had 4 extra years, going into the 5th year with Corey from his first transplant, that I would never have had. And those 5 years, I had got married last year and Corey was my ring bearer. We've been on holiday. We've had lots of lovely days out. We've had lots of experience with Corey. He started school. He went on his first school trip. He got himself a girlfriend, you know, and now look, he's an internet sensation, and he has all of you supporting him. If you can give the gift of life, please do so. It will be the greatest, most selfless act that you can do for anybody.
Okay, so what advice do you have going for those going through tough times themselves?
Spend as much time with your family as possible. Do everything you love, do everything what makes you happy, never give up, and just fulfill all your life's dreams.
Hey, so do you have any response to your fans out there who are thinking of you?
You guys, all my fans, you are so amazing. You have no idea, I mean, no idea how much support, how amazing you are. You think you're just supporting me, but you think so much more. You guys are wonderful.
Okay, so what inspirational quotes can you think of to give other people?
Grab life by the balls and never give up. Like, proper grab them.
bitches.
I'm proud to be one of Corey's bitches, and I hope you will follow his lead and go subscribe not only to Crack in the Box, but to his mom's channel, The Crap Goth. That was really actually one of Corey's final wishes. He wanted to see his mom's channel succeed like him because that's the kind of kid he was. He was always out there to think of others. And I hope you guys will help his family right now and go support them and help to continue his legacy, because I believe there's more to this story. In fact, you can subscribe to both channels, Crack in the Box, The Crap Goth, and then you can go the extra. You can go give to Rainbows. Rainbows.co.uk, a wonderful organization, a hospice where he was helped. He did a tour of this place, amazing facility that helps children going through similar situations as to Corey, the unimaginable situations of life that no family should ever have to face. And I want to send every family there, as well as Corey, his entire family. They're amazing, and I send them so much love and positivity, and I'm going to give them their space, but I hope they know we are here whenever they need them. It's going to just take time. But this little boy of yours will never be forgotten. He was such a bright, fresh air and light, and we love him. We'll always love him, and we always got his back. So go subscribe, bitches. Thank you for watching. We'll be back with more here on Popcorn Planet. Love you, Corey.
In Spokane County Superior Court in Washington State for a first appearance hearing. 81-year-old Howard Patton is accused of custodial interference, criminal impersonation, and forgery. A second-degree kidnapping charge has also been filed against him. 3 days earlier, a social worker notified Spokane police that a teenage girl was missing from her foster home. She'd been placed there after her father, Daniil Bagmet, was arrested and charged with assault for strangling her. It was also determined that her mother, 51-year-old Galina Bagmet, couldn't protect the girl from her father. The foster parents claim that the girl's mother came to their home with Patton, who said he was a lawyer. Patton gave them what appeared to be legal documents that threatened them with execution by firing squad, among other things, if they didn't return the child to Bagmat. The foster parents, who are Russian immigrants, thought the papers were legitimate, so they allowed Patton and Bagmet to take the girl. Police found the teen and her mother at the Bagmet house the next day. The girl was returned to foster care, and Galina was arrested and charged with custodial interference. During the investigation, Patton arrived at the Bagmet home and was also arrested and charged. Daniil Bagmet was not at the house and has not been charged for this incident. Today, Patton is before Spokane Court Commissioner John Stein to determine probable cause in the case and to set bond. Patton, who identifies himself in court papers as a sovereign American national, employs a standard sovereign citizen opener, quibbling over his name as the hearing gets started.
Is this the Howard Patton Trust you're talking about? I'm appearing as a living man.
But the commissioner is having none of it.
Sir,
I don't want to hear any of your constitutionalist crap. I mean, just save it for somebody else who's stupid and believes in that. You're here on charges of second-degree kidnapping. I found probable cause for that offense.
But Patton's public defender challenges the probable cause finding on the kidnapping charge.
It's unclear that Mr. Patton was actually the one who took the youth away from the home physically. And I'm looking at these, and we don't have firing squads. This is not something that is going to happen. And there were no direct threats made other than what was in this paperwork.
Obviously, anybody who's familiar with the court system and all can tell all this paperwork he gave to these people is total nonsense. However, if you're not familiar with court paperwork and realize this was a Russian family, they may not know much about the United States, and somebody who claims to be a lawyer handing them what they're claiming is legal documents, threatening them with being deported and property confiscation and all kinds of other malarkey may take it seriously. I will set the $150,000 bond. That's all for today.
2 weeks later, Patton was back in court before a different judge, and this time refused to enter a plea.
I will not enter a plea that will give you jurisdiction.
So the judge tried to enter a not guilty plea to protect Patton's right to trial.
Is somebody to enter a plea of not guilty?
You don't have the power, sir. For the record, you do not have the authority to dictate or conduct law from the bench.
Patton remains in Spokane County Jail, awaiting trial. The girl remains in foster care. Her mother, Galina Bagmet, has been released pending trial. Her father, Daniil Bagmet, is free pending his assault trial, but has been ordered to have no contact with his daughter. Thanks for being a fan of Court Cam. Subscribe to A&E to never miss a new video and catch full episodes on aetv.com. We're in Berea Municipal Court. The defendant, 21-year-old Milton Watts, has turned himself in after a warrant was issued for his arrest for failure to appear on a domestic violence charge.
You were supposed to be here last month. You did not appear. Why weren't you here?
My mom didn't show up. Somebody died in the family. There was no reason for me to be here.
Well, it's not an engraved invitation, son. It's a court order.
Things are clearly off to a rocky start between Watts and Judge Chris Green. But Watts seems comfortable handling the situation on his own.
Your attorney withdrew, so you'll have to hire an attorney?
I don't need an attorney.
You're a lawyer?
Nope.
Unfortunately for Watts, his grasp on the legal process seems spotty at best.
Do you want to talk to me about a bond with me? What do you want to tell me?
About what?
Bond?
I don't really give a to be honest with you.
Judge Green, who's known for his no-nonsense style, doesn't seem particularly receptive to the attitude.
That's going to cost you 30 days in the county jail for contempt. Cuff him if you got the cuffs. Hold on. It's $5,000 cash surety bond, subject to the temporary protection order.
Watts' remarks have already cost him dearly. And now he doubles down.
He just swore at the judge. Can I give you a piece of advice?
What?
You can either make life easy or you can make life hard.
I already ruined my life.
That's 60. You want to go for 90? That's 90 more. That's 180. That's 306.
Now I gotta come here and my life up. You.
Melvin, stop.
How many days you want to give me now? Are you still counting?
Melvin,
Yeah, I'm at about a year right now in contempt, so.
Watts' mother and sister attempt to intervene, but there is no stopping the foul-mouthed tirade.
I don't care.
I don't give a you.
Melvin, stop.
Everybody. You.
Melvin.
Power.
Good.
Fight the power.
Good.
Said you.
That's stupid. Melvin, stop. Stop it. You're not even getting in trouble. Melvin, listen. You're going
Who the you keeps telling me anything?
Listen. No.
Deputies and other court staff quickly arrive at the courtroom for backup.
Melvin.
Just let him do what you're not going to do anything. Just causing more.
That's ignorant.
That's the way he is.
Despite the judge going all the way up to 360 days in the heat of the moment, once Watts calmed down, the judge ultimately decided to reduce the sentence to 90 days in jail, or 4 days per four-letter word. For the initial domestic violence charge he was originally in court for, he later pled no contest and was sentenced to 5 days in jail. Thanks for being a fan of Court Cam. Subscribe to A&E to never miss a new
don't consent to being called by the name that this court chooses to identify me by. I want to state for the record that I'm here as a third-party intervener on special appearance on behalf of my client. Can that be noted for the record?
Was noted this morning.
May it be noted again for the record so that we can keep the record clear and accurate.
The appearances are as they were this morning. They are no different. Bring the jury up.
And we have yet to address subject matter jurisdiction, Your Honor. I still haven't been shown any verified proof that
All rise.
this court has subject matter jurisdiction. And at this point, may I request an affidavit that you, Your Honor, have no bias, no conflict of interest, and no interest in the outcome of this case?
Mr. Brooks, the jury's coming out. We'll address your legal issues later, if I deem them appropriate.
Judge, do you hold the full
Mr.
judicial
Brooks,
power of the
please,
state, or is this the
please.
military
All right,
power?
Can you please take the jury out? Thank you.
Do you hold the full
Mr. Brooks, just
jurisdiction?
wait till the jury's out, please. I ask that you show that respect.
I will.
Thank
Your
you.
Honor.
Everyone else can be, you all can be seated. Mr. Brooks, just make your statements. What do you want to advise the court today?
I want to first state again for the record that I do not identify by that name, nor do I consent to being called that name. Your Honor, with all respect, I'm merely asking you, do you have the full judicial power of the state, or is this military power?
I'm sorry? I don't understand what you're asking me, sir.
I'm asking, is
And on what
this,
legal basis are you making that request?
I'm asking for the record, is this a common law court or an admiralty court? What are we in here? And I'm requesting an affidavit that you, Your Honor, have no bias, no conflict of interest, or no interest in the outcome of this case. And the reason why I want to state this clearly for the record, mainly is because of the bias that's been shown. I have not been getting any certified copies of any requests that I've made, which I was told by this court to address inmate communication forms for anything that I may need. I've done that. I've complied with that. Every time I've needed something of the court pertaining to documents, I've done it the way the court has asked me. And I've always stated that I wanted everything to be certified. I have yet to even get that. My court docket sheet was not a certified copy. When I asked Your Honor of your oath of office, I asked for that to be certified. You stated for the record that you would not give me a certified copy of your oath of office, which you are required to show if I ask for it. I've brought up my Sixth Amendment constitutional right that has been pretty much discarded, and that is based on the fact that I have the right to face my accuser, which would be the plaintiff, state of Wisconsin, in this matter. They have yet to show that a claim is I mean, a living human being can only make a claim. An entity cannot make a claim. I've requested for the complaint to be provided. The complaint from November 23 of 2021, the amended complaint from November 29th of 2021, the second amended complaint from January 12 of this year, 2022. I have yet to see those. There was no record of a bond in my docket sheet. I asked for that to be verified by proof. That hasn't been provided. There's so many biases, clear biases in questions that are not being asked based on judicial determinations made by Your Honor. You look at the discrepancies, and I think they're clear. I think at minimum, I deserve for the subject matter jurisdiction to be verified and proven. I've raised that issue numerous times, pretty much every day, every time I come before your court, Your Honor, I address that, and it has yet to be proven. My filings have been disregarded, even though they've been filed into the record, even though they've been time stamped. I haven't got the original copies of any of them, which I'm supposed to get. And as we sit here today, I'm still not even understanding the nature and cause of the charges. That hasn't even been proven. Can that be provided in any way? I'm basically sitting here confused because I don't understand why these proceedings are allowed to continue when there's so many things that have not been provided. They haven't been provided in my discovery. They haven't been provided to me by being brought to my pod where I'm housed in the jail. I'm without so much information, valid information to this matter. And I believe that it should be verified and it should be proven for the record. And if not, I move for this case to be dismissed for failure to appear by the plaintiff and failure to state a claim for which relief can be granted. Everything that I'm saying, it has merit and it has validity. As we sit here today, I'm still being charged with charges that shouldn't even exist based on the testimony that we've heard for the last few days. There's so many things left to still be proven. The prosecution team hasn't even proven that they're licensed to practice law in Wisconsin. They haven't proven, are they just bar association members, or do they have state issued licenses? That has not been proven, which I've raised that issue for the record. I'm not even sure if that was even recorded in the docket sheet. There's so many things, and Your Honor, you still haven't stated for the record if you have full judicial power of the state or is this military power. That hasn't been proven. Nothing has been proven. Not subject matter jurisdiction, not licenses to practice law. My Sixth Amendment right has been basically trampled over. No complaints have been shown. Neither of the three that I've requested, by the way that you told me to request them by inmate communication. Nothing gets certified that I get copies of when I clearly asked for them to be certified and to be filed into the record. It's to the point where Your Honor, you should recuse yourself from the presiding at this point. If you're not going to abide by the oath that you swore, which was in your oath, correct? You swore to protect the Constitution of the United States. You swore to protect we the people. That is not being done here. If every valid argument that I raised is taken by the court as a sign of disrespect or a sign of trying to intentionally be disruptive or causing a problem, when I'm merely seeking understanding, because I don't understand. I'm merely seeking to understand why this information has yet to be provided and we're this far into this matter. And there's still no verified proof. Even as I sit now saying this, there's still no proof being provided. Zero. How is this case allowed to continue without these documents and filings being verified? Is there any legal factual basis that can state why this information has not been provided? Why the docket sheet is incorrect? Why there's so much on the docket sheet that should be on record that's not even in there, that if we had the recordings of the record, they would see was brought up numerous times that doesn't even show up. I'm just asking for your honor to be fair, which is another right that I have, the right to a fair trial and the right to an impartial jury. I can go on and on and on about what's not being done. I have, again, I say I have the right to face my accuser. Where's the injured party? Who's making the claim? I asked your honor numerous times for your honor's name. You wouldn't answer. I asked, did you have a claim against me? You did not answer. I asked the whole courtroom, did anyone have a claim against me? No one said anything, which you stated for the record, a non-responsive answer. A non-responsive answer is an agreement, which will be a tactic agreement by you, your honor, that you don't have to answer these questions that you should be answering. I have that right. The plaintiff in this matter, which was stated by witnesses in testimony to be the state of Wisconsin. But when I asked, do they see the state of Wisconsin present in the courtroom, the question is shut down, which is a valid question. The plaintiff should be present in this matter. Where is the plaintiff? Who's bringing the claim? Because we know an entity can't bring a claim. It has to be a living, breathing human being. No one is stated for the record if they're the injured party. Not your honor, not the prosecutors, not anyone in the court has stated to be an injured party in this matter. No one. Not one person. I have the right to demand that the court place in the evidence any unrevealed contract. Has that been provided to me? Have that been placed in the evidence? I would like to see it, which is my right. I have the right to inform the jury about the truth and their duty and their rights. That's the First Amendment and the Sixth Amendment. But I'm repeatedly told to shut the question down when this is valuable information that the jury should be privileged to know. They deserve to know. Once they were chosen to sit on this jury, why are we keeping information away from them that they deserve to know? They ultimately have the power. They decide the matter. Why are we keeping information, valuable information, from their knowledge? That's a disservice to the jury. And frankly, it's a disservice to the court that they're not allowed to hear things that they should know, that they should be informed of. It's our right to inform them of everything that they have the power to know, to do, and to know. They deserve that much. It would be a travesty for them to make a decision without being fully informed. And these are all valid things. I have the right to protest and object if any of my rights or demands are not being met. I've done that numerous times only to be shut down. Numerous times. I've raised the issues that I didn't consent to anything that may have been suggested on behalf of my former attorneys. I've never even consented to them making a plea on my behalf. I haven't, as a matter of fact, when it comes to a plea, I haven't even had the opportunity to entertain any plea that may have been suggested by the prosecution. We haven't even talked about that. Not one time was it ever brought to my attention that the prosecution even wanted to offer a plea. That's another issue. I have the right to challenge the jurisdiction of this court, which I've done numerous times. I have the right to demand that the code be construed in harmony with the common law. I just raised that. I'm constantly referred to as pro se when I've raised the issue that I'm pro per. I have the right to conduct my defense pro per, free from professional restrictions imposed upon licensed attorneys, which this court is well aware that I am not a licensed attorney. In fact, the court is also aware that I only had 3 days to prepare for a trial that the prosecution has been prepared for a whole year. We see these boxes right here. This box alone is
just to refresh the brief memory here, our memory. Just to refresh our memories before the break, we were, I was asking you that in the investigation of your case and in investigating his phone, that you had found the video of him with his children.
Yes, that's correct.
I'm going to show you what's been marked as State's Exhibit 558. It's already been admitted. Recognize this video. It's USB.
Yes.
Okay. Permission to publish, Your Honor.
Go to bed. Go to bed. Go to bed, I said. Shut up. What are you crying for? You dramatic little shit. Go to bed.
That's enough, guys. Did you identify whose voice that is?
Yes,
Whose voice is that?
it's the voice of Ronald Anthony Burgos-Aviles.
Who else is in the video?
It is his toddler son.
Objection, Your Honor. What's the basis of knowledge?
Well, if you know. That's it, Your Honor. No further questions.
All right. That's the witness been passed. Any questions?
Good afternoon, officer.
Good afternoon.
Now, you've testified now 2 times to this jury. Is that correct?
Yes,
And you testified today and last time that you did a phone dump of Ronald Burgos-Aviles' phone. Is that correct?
that's correct.
And you recovered a lot of items during that phone dump.
Correct.
Okay. And you got a search warrant in order to take control and possession of that phone, correct?
Control possession, search warrant
Yes, sir.
for the dump.
Well, you got a search warrant in order to search.
Yes, in order to search the phone, yes.
And I could just have. I think it's State's Exhibit 559. Is it still?
559, 558? Everything's in place over here. That's 558? Was there 559?
Yes.
Okay.
and I said 559, but I believe this is the exhibit 556 that Mr. Alanese went over with you of Mr. Burgos-Aviles' text messages. Is that correct?
That's correct.
Okay. And you obtained that search warrant to take possession and search Mr. Burgos-Aviles' phone on April 10th, correct?
Correct.
Okay. That's the day after the murders. Is that correct?
That's the day after the murders, yes.
And want to
There you go.
I'm sorry, I struggle with the okay, and on direct examination with Mr. Alanese, he directed your attention to this text message, which was to Renee Alejandro, the supervisor of Mr. Burgos-Aviles, correct?
Correct.
And it indicates LPD Detective Ray Garcia, and then gives an office number, a cell phone number, and says taken over scene, correct?
That's correct.
And that is, you are Detective Raimundo Garcia, correct?
That's correct.
And I believe you said on direct examination that that was you texting from Mr. Burgos-Aviles' phone. Is that correct?
No, that's not correct.
Okay, well, who was texting? I want to look at the time is UTC 9:25, so that means it's 4:25 p.m. Is that correct, sir?
That's correct.
Now, you're not telling this jury that it was Mr. Burgos-Aviles who was texting from his phone at 4:25 p.m., are you?
No, I'm not. No.
So, well, do you know who it was who was texting from Mr. Burgos-Aviles' phone at 4:25 p.m.?
I don't. No.
Because I believe, if I remember correctly, you said that Mr. Burgos-Aviles was taken into custody a little before 2 p.m. Is that correct?
That's correct.
So at the time this text message was sent, he was at the police station in the video that we watched with Detective Reyes, correct?
That's correct.
So I think it's safe to infer then, sir, that it was not Mr. Burgos-Aviles who sent to his supervisor your name, your phone number, and your cell phone number, and indicated that you had taken over the scene, correct?
That's correct.
But you don't know who that was, right?
I don't know who that was.
And I'm sorry, I jumped a little early. Now I said that that's 4:25 p.m., correct?
Correct.
And what date is that, sir?
That's April 9th, 2018.
Okay. So, and again, you said that you obtained the search warrant on April 10th. Did I understand that correctly?
That's correct.
Okay, so it's clear that prior to you obtaining the search warrant on April 10th, that someone had taken Mr. Burgos-Aviles' phone at that time and were texting his supervisor your name and your information, correct?
I object to speculation. You said he didn't know. He doesn't know. So overall, let's answer the question.
Yes. Can you repeat the question, Mr. Rogers?
Well, prior to you obtaining the search warrant, and while Mr. Burgos-Aviles was in custody, you don't know who was texting his supervisor your name and your contact
Yes,
information.
that's correct.
Now, you had previously testified, I believe, at the first phase, the guilt phase, about Facebook messages that you obtained in this case. Is that correct?
Yes.
Okay. And the district attorney went through and selected many Facebook messages with you and highlighted them with you. Is that correct? You remember that?
Yes.
And it was the district attorney who selected which Facebook messages he wanted to discuss and show this jury. You remember that?
If he was pointing at the messages, yes.
Okay. Now I am marking this as defendant's exhibit number 10. 10. Yes, sir. And you recognize that as a page from the Facebook messages that you extracted or that you dumped from Ronald Burgos-Aviles.
Yes, correct.
Correct? Okay. And that's a fair and accurate representation of a page of those Facebook messages?
If you're saying that it's from the Facebook, it is. I recognize some of those messages.
Okay.
Yes.
And so.
Any objection?
It's accurate. It's accurate.
No objection.
No objection.
Admitted.
May I publish to the jury, Your Honor?
You may.
And, sir, in fact, during our guilt phase, the district attorney, I believe, referred you to this specific message from March 26th, and then the UTC time is, it's March 26th, UTC time is close to 1 a.m., which makes it about what time, Laredo, sir?
Laredo, it would be 10, 9, 8, 7,
It's not fair. It's
7.
about 8 o'clock, right? 7:56.
7:48.
7:48.
The next, the previous day, March 25th.
March 25th, the same day as the visit to the Winfield Park, which you discussed previously, correct?
Correct.
It was the day that Dominic suffered an injury on his leg.
That's correct.
And from your understanding, Dominic was taken to the hospital that day, correct?
That's correct.
And the district attorney asked you about this message saying, you know, he can get necrosis, right?
Yes.
Okay. Now, the district attorney, I want to make sure everyone can see this, and that was from what you have identified as Ronald Burgos-Aviles' Facebook account, right? Roro Abbey?
Correct.
Okay. Now, the district attorney did not ask you about two messages above from March 25th, and that time is about what time, sir?
It's 7:53.
I'm going to object. That's mischaracterization. He read all the messages, Your Honor. I don't know. But
Overall, the jury will, I'm sorry, it's cross-examination, so we'll take.
So at this message at about 7:53, the day of the injury, it's actually Mr. Burgos-Aviles who indicates that Grizelda should take Dominic to San Antonio. Isn't that correct?
Yes.
It says, and it's from Roro Abbey, right? You should take him to SA, and you understand SA to be San Antonio, correct?
Yes, I do. Yes.
Okay. Or something tomorrow, right? So it was Mr. Burgos-Aviles who was suggesting that she take Dominic to San Antonio, and it was the same day of the incident.
That's correct.
Okay. And he said you should take him tomorrow. Now, from we understand in your investigation of the timeline, this is when it seems as if Grizelda is messaging on Facebook with Ronald Burgos-Aviles from the Bad Bunny concert. Is that right?
From here?
Well, I mean, from the time and the date, it's before 8 p.m. on March 25th, correct?
I remember, yes, there was mention of a Bad Bunny concert, yes.
And so, Mr. Burgos-Aviles, who is convicted on March 25th, the same day it happened, actually suggests that Dominic be taken to San Antonio. We
Yes.
established that, yes, sir.
Mhm.
And then he actually warns her about necrosis. Isn't that right, sir?
That's correct.
And you were the lead attorney on this big and important case. The lead attorney, I apologize.
Yes, I was the
You were
lead
the lead detective
investigator.
on
Yes.
this, investigator on this big and important case. And you worked in the capers, which is the crimes against persons unit. Is that
Yes,
correct?
that's correct.
That's an important unit, correct?
Correct.
And you've worked a lot of cases. Is that correct?
That's correct.
Okay. Now, you have heard the state's theory that Mr. Burgos-Aviles, oops, you can see my question. Now, you have heard the state's theory that Mr. Burgos-Aviles injected Dominic with something on March 25th, correct?
Correct.
Now, having worked so many cases and crimes against persons, have you heard of a time where the person who assaulted someone said they should go to the doctor and then gave them a hint about what it was they were poisoned by?
I've had cases where people get assaulted and they say you better go get that checked.
Well, if someone was trying to get away with poisoning someone, would they direct them to something to cure them and tell them where they should go to get cured?
Yeah, I guess so.
I apologize. You guess so? What does that mean, sir? I'm sorry.
So, it is plausible.
Now, you've also heard the state's theory that and he's convicted. So I understand these are, there's a bigger picture here.
Yeah.
But you've heard the state's theory that Mr. Ronald Burgos-Aviles told Grizelda that his name was Anthony, correct? Or that she knew him by Anthony.
Yes.
Okay. Now, these messages, the author is Roro, correct?
That's correct.
Now, you wouldn't assume that Roro is a nickname for Anthony, would you?
No.
Okay. Roro would be a nickname for Ronald, correct? More
Yes.
likely.
More than likely, yes.
Okay. Now, you testified on direct examination, I believe today, about recovering child support papers that Grizelda filed against Mr. Ronald Burgos-Aviles, correct?
That's correct.
Now, those papers were filed February 1st of 2018, correct?
Yeah, February 9th.
Well, are you sure it's February 9th, sir?
Yes, I believe so.
Okay. I believe, and again, I recognize that this is not the bigger picture. He's convicted.
Mhm.
And I believe this is, I'm marking this as Defendant's Exhibit 11. Yes, Cindy. And Officer, you recognize Defendant's Exhibit 11, correct?
Correct.
Okay, that's the cover page to the application that Grizelda Hernandez filed against Ronald Burgos-Aviles, correct?
I don't know if it's the cover page, but it's definitely one of the pages.
Okay, sir, if I could direct, you've seen that document before, correct?
Correct.
Matter of fact, it's in evidence as part of the state's case, correct?
Correct.
And there's a date in that lower right-hand corner, correct?
That's correct.
And what does that date say?
It says February 1st,
Okay,
2018.
All right, and so that was a long way to go. So did Grizelda Hernandez apply for child support on February 1st or February 9th, sir?
This is an application that she filled out, and she dated it February 1st, 2018.
And on that application, she indicates the father of Dominic's name is what?
Ronald A. Burgos-Aviles.
Okay, so we know that on February 1st, 2018, right? So more than 2 months before she's murdered, she knows Ronald Anthony Burgos-Aviles' full name as Ronald, correct?
Correct.
Okay. And like I said, I know that this isn't the big picture. And so I thank you for your patience. Can I have that back? Do you have time? Yeah. I just-
Wanting to make sure I try and give some time to one of you all that needs to get to somewhere. I want to go ahead and cut off for the day. So tomorrow I'm hoping that I can keep you all here during lunch hour. So maybe we can have a shorter lunch period and just, all right. So we'll order something for you all tomorrow to eat here. So don't make any plans to leave here at noon. All right. We'll excuse you for tonight. We'll see you tomorrow.
Oh, how cheap. They haven't been feeding the jury all this time. What they pay a jury here wouldn't pay for a really good lunch at a top restaurant. Okay, yes, they are done now. So, I guess he'll probably say something after the jury goes out. I assume that it's the same theoretical start time in the morning. So, I'll figure on 7:45. And who knows, maybe they'll even start on time for a change. And I'm going to be making my run up to Layton. So, no, is he not going to come back on? I suppose there's nothing interesting really if he does at this point. Okay, well, I'm going to call it. We'll see you all tomorrow. Have a good night, Indiana. It must be getting late for you. We'll see you in the morning. Bye-bye.